Second.
The one you have in your folder should be.
Oh, okay, yeah, I don't remember seeing that.
Yeah.
The second one is still.
Yeah. London is taken.
All right, we will call the meeting to order, please. Good morning, my name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. Additional agendas, including the consent agenda, available in the back of the room. Consent agenda is a listing of cases in which no written arguments were made to the commission in the amount of time the commission has voted on those cases, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium, provide the most relevant arguments to the case. Time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only relevant factual errors, relevant omissions from the report of facts submitted during the investigation, relevant issues and questions concerning interpretations of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself and come to the podium or are recognized online. With that, we will proceed with the business portion of the meeting. First item of business is acceptance of agenda. Do I hear a motion? Second. Seconded that we adopt the published agenda. Any discussion? Hearing none. All those in favor?
Our remote participation policy requires that you indicate your vote both verbally and visually.
Okay. You wanna call us?
Sure. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. And Commissioner Walker is out sick today. So the annual cold.
So, business meeting kid.
Yes, so first is the minutes of the December 2024 commission meeting. Motion to adopt them. So moved.
Second.
Any discussion?
I wasn't here, so I'm not gonna.
Okay, thanks, Julie. If you are in agreement with adopting the minutes, you will vote yes. Commissioner David?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
So for reports, no change in personnel. Everybody knock on wood. The numbers in your sort of summary memo about conciliation are wrong. I don't know how Excel got them, but those are not correct. So I will give you the correct ones are in Jane's memo, which you all do have. There are 7 cases in active conciliations, 1 failed, 1 successful, and I have 2 agreements for which I need your approval and also approval to sign on your behalf. Those are H24-0110 Nuanco versus North River Holloway and all.
It's just a quick question. Sure. I see the Nuanco matter, where the respondent is Red Pullen.
There are 3.
Oh,
Yeah.
okay.
I named North River Hathaway, sorry, not Holloway. I tend to name the corporation first. Okay. But okay, so, yes, so Nwankwo versus North River Hathaway et al. And PA 22-0308 Stone versus Barbecue Garage. So do I have a motion to approve and sign? Oh, Julie.
Good, just quick question, and I haven't been able to pull it up yet, but I mean today, but I read it. When I assumed that both parties to the agreement had to sign. And I believe, again, I'm gonna just say the wrong thing because I can't find it, but I do remember that the planning had not signed.
In Nwankwo. This.
And I went back to see if
It's Jane. So Jane runs the conciliations. It's possible that she just didn't include the complainant's signature page in that. In any case, I think the terms have been agreed to by everybody and we might just be waiting on her signature. So if you approve of the terms, I'm happy to amend that motion to approve it as soon as we get complainant's signature. Right, motion to adopt those, to approve those agreements.
So moved.
Any further discussion on this? Okay. If you are in agreement, you will vote yes. Commissioner David,
Yes.
Commissioner O'Brien,
yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
For investigation. This is for November and up until I think December 29th, which was sort of the latest date that we could run a report and get it to you in time. 65 new charges with a total of 97 respondents. 34 administrative dismissals and predetermination settlements, all of those closures. 6 administrative dismissals for lack of jurisdiction reasons. No right to sues this time. You know what, that number also can't possibly be correct. We're working with a new report. I don't know what happened there. 1 second while I pull this up. Anyway, we had 12 predetermination settlements, 8 through the commission's mediation program for private settlements for a total of about $274,000 to complaints. Yes, okay, here's what I did. I put the wrong numbers in there. 34 administrative dismissal letters sent, 6 right to sues. That's rare. That's better. I will fix that next time. That's all for business stuff. I would ask that we take litigation in executive session. And the only thing for new business is that the legislative session has started. I got an email this morning asking me to come introduce the commission to the Judiciary Committee for weeks. We're in it now for until the session is over.
What does it introduce the commission?
I think they do this most sessions where the agencies that committees have jurisdiction over, all of those committees or agencies come and introduce themselves. So I will be doing that, answering their questions and
Right.
I think alerting them about any of the bills that we proposed. So if you remember, we put 3 forward. 1 to make a couple of tiny amendments to the MHRA so that we reference the correct provision of Title 19 in our references to permanent protection orders. And 1 to make a correction from husband and wife to spouses in the credit extension section of the bill law. 1 to change Barbara to a major policy influencing position, and 1 to provide sort of immunity from or indemnity to the mediators while they're mediating.
They don't have that?
They do not have that, and it is a problem for their liability insurance.
Certainly would be.
So DOE mediators have it. So we basically just copy the language from the DOE statute that,
Family law mediator,
so
I believe.
it would, yeah, better check. But it would basically make them all covered. Yeah. It, literally, we'd had the program for 10 years before, and we had the contract, and
Yeah,
that's when everybody was like, oh, I see this indemnity provision, because one of our mediators also mediates with you. So this would cover them under the Maine Tort Claims Act, basically, just for the purpose of mediation. I have no other reports for you. Question? Susan?
okay, we'll be in recess for about 3 minutes and start
athletic
Great.
approach to this, these proceedings, so.
one more life experience, that somehow all relates.
Okay, we will call the meeting to order. The cases for, and proceed with the cases that are scheduled for hearing today. The first case is E22-0346, Robert Witt versus Mount Blue Drug. I believe our executive director has some general rules about the presentations, but the case is a recommendation that the commission find reasonable grounds to believe discrimination existed, and therefore we would hear from respondent first. And the record should note that I personally am accusing myself because of local connections.
Yes, so the commission's confidentiality rules and regulations require that we not say the names of anyone who is not a named party in the case. So we just ask that you either use the sort of pseudonyms that have been created in the report, some other non-identifying word or entities that are not named in the case. I believe Attorney Strader. You have 10 minutes. Do you want to reserve any of your time?
I think that depends on whether or not there's a rebuttal. I'm not sure if the party.
DeWitt?
Yes. I thought so, but I've met him once, so. So yes, I would probably 2 minutes. Good morning, commissioners, executive director, commission counsel. My name is Dan Strader and I represent the respondent today. We've objected to the investigator's report and recommended findings on essentially 2 bases. One, strictly legal. We believe that the commission lacks jurisdiction due to the failure to complete its investigation within the mandatory 2-year period. And one is sort of a mixed question of, or mixed, I guess, issue of law and fact. To turn first to the jurisdictional requirement, the enabling statute that provides the commission its jurisdiction and its authority to take action, to investigate complaints, and specifies the actions it may take on those complaints, states that the commission must conclude its investigation within 2 years after the complaint is filed. That is a mandatory time limitation. I do not believe it's aspirational or a recommendation. It is a mandatory time limit. It's undisputed here. The commission took more than 2 years well, it hasn't yet issued a finding, but the investigator's report came out more than 2 years later. There's a reference to some sort of unspecified procedural issues within the commission internally. It had nothing to do with the parties. And I just don't believe that I think it's black and white. I mean, there's really no basis to say that the commission can act outside of that 2-year window. I would analogize this to the 300-day filing period that complainants have. Complainants that file outside those 300-day window, absent some, issue of tolling or, waiver, which obviously isn't present here because the parties haven't done anything in that regard. That is also a mandatory period, and the commission lacks jurisdiction to pursue complaints filed outside that 300-day window. I don't see really an argument that there's a different result here. So I would also point out that there's no prejudice to the parties here. There's no prejudice to the complainant. The complainant would, upon an administrative dismissal, would get a right to sue. He would have all his rights and remedies to go to court. He wouldn't be losing anything. And so it really just, it's a bar on the commission. It's a bar on what the commission can do. So I would submit that the only real option available to the commission today is to dismiss this complaint for lack of jurisdiction and not to issue any substantive finding at all. I'll pause briefly there in case there's questions or comments on that issue before I move on to the actual legal question.
We'll do all the questions at the end.
Sure. In terms of the factual errors, and I think these are combined because I think there were some serious factual errors that were made here in the report that then also led to incorrect legal conclusions. So basically the investigator found pretext based on two key facts that he found to be established. One was that he said that the respondent acknowledged basically adding a disciplinary warning to the complainant's file post termination. And he also said that there was basically a lack of dispute, that the parties acknowledged that the complainant engaged in protected activity in the fall of 2023. Neither of those findings is factually accurate, and I think both were based on evidence that should never have been considered. So obviously, we're not under strict federal or state rules of evidence here. I understand that, but there is some due process requires a minimum reliability standard, right? You can't just rely on any evidence. And here, the investigator relied almost exclusively in terms of reaching those two conclusions on scattered pages from a workers' compensation transcript in a separate proceeding involving the same parties, in which, and they were totally unreliable. I mean, you have 10 pages out of a 200-page transcript. They're not in order. There's missing pages in between. It's not clear who's testifying, what they're testifying about. They're referencing documents that are not attached. And I think the investigator erroneously thought that in one instance, he says that the pharmacist in charge, who was the person who issued the written warning, he says that the pharmacist in charge testified at the workers' compensation hearing that she had never issued a written warning to the complainant. That's not true. The pharmacy director testified at that proceeding, not the pharmacist in charge. And the pharmacy director said that she did not issue him a written warning. That is true. She did not. But the pharmacist in charge did. The pharmacist in charge did not testify because she was no longer employed at the time at the fact-finding conference. But the investigator had every opportunity to ask the parties questions about that transcript. Frankly, it never even occurred to me that that would be something that he would heavily rely on. It was not addressed in the fact-finding conference. No questions were asked about this testimony. What did you mean here? What document were you referring to? And I think it caused a serious error in the factual conclusions that he reached. So there was no admission that the written warning was not issued. In fact, the complainant, and this was, I think, also a serious error. At the fact-finding conference, the complainant kept talking about this written warning being fake. It wasn't signed. It's a fake warning. And when I asked him about it, because I got an opportunity to question him at the end, and I tried to clarify with him, when you say it's fake, you didn't sign it, correct? Yes, I didn't sign it, but you disagreed with it, right? That's the issue. And he said yes, but he admitted that he got it. So the idea that it sort of was made up after the fact is just not true. And I can certainly understand why, if someone fabricated a written warning after the fact, you would say, okay, that's evidence of pretext. But that didn't actually happen. So then for the pretext finding to be based, as far as I can tell, more or less exclusively on that issue, I think it was a serious error. There was also, I think, really short shrift given to the legitimate reasons for termination here. The investigators sort of characterized this as like part of an ongoing issue of performance that had been happening over 2 years. That ignores the really acute and specific concerns that were raised his last day of work, which you had 2 pharmacy technicians working under him that both reported to the pharmacist in charge that they were uncomfortable working with him, that he was refusing to initial prescription bottles, again, after just receiving a written warning for that. He was ranting and raving about his disciplinary warning. He spent 20 minutes in direct quote, shit talking the pharmacy ownership and the pharmacy director. He gave syringes out for free to a customer on video. And he showed the technicians how to hide from the security cameras. And he admitted this, by the way, in the conference, to hide from cameras so they could violate policies. And so this was not just it's more of the same. There was no precipitating event. There was a very clear precipitating event that led directly to the termination. So there was a very well-established legitimate reason and really no evidence of pretext when you strip away the incorrect factual findings. And I'll pause there and reserve the rest of my time.
I'm sure, Attorney Strader, that there will be commissioner questions for you if you want to stay up here.
Oh, sure.
I just have to write down how much time you have left before I forget. Commissioner questions for Attorney Strader.
Yeah, just one question. Thank you for coming.
Thank you.
For your submission closely, and it's helpful, persuasive. With respect to the transcript that came from the workers' compensation proceeding, understanding, I think what your position is that the complainant selected pieces of that transcript to provide to the commission to support his version of events. Did you supply did your client supply the full transcript to the investigator as part of this fact-finding process?
We did not, and quite frankly, and I didn't address any of it here because we're precluded from doing that and submitting new information. Quite frankly, as I said, it never came up during the fact-finding conference. It did not occur to me, quite honestly, that would ever have been considered because it seemed to me so clearly to be inappropriate evidence. And the fact that it was never discussed at the fact-finding conference, I would have expected that if that was something that was being considered, that there would have been questions about it. So no, I did not.
Just to clarify though, you were on notice prior to receiving the investigator's report, correct? That the complainant was relying on pieces of that transcript to prove his claim.
We did have the pages that had been attached to his reply. Whether or not we were on notice, yes, we knew that the pages had been attached. Again, it didn't come up. So it wasn't really clear to me to what degree that was going to be at issue. And I certainly did not believe it was going to be the cornerstone of the findings. But
thank you
yeah.
for that. Question two about, I think you just characterized reliance on the workers' compensation proceeding as sort of giving rise to inappropriate evidence, quote unquote, inappropriate evidence in this context. Tell me more about why.
Well, so I don't think if first of all, I think there's really no reason to rely on a transcript of another proceeding when you have the parties there and you can question them, right? That's not typically what you do in any evidentiary context. You're not introducing depositions other than to impeach, obviously, right? But you typically don't introduce out-of-court testimony when you have folks in court, or in this case, in a conference, in a proceeding that they could testify directly. And so, no, I don't think that was really appropriate on any level. But what I take particular issue with, and again, we now don't have the ability to look at the full transcript, but it's taken out of context, and if you're going to rely on a transcript, you certainly should have access to more of it than 10 pages. I wrote them down in my submission, but it's like page 165, then page 172, then page 190, right? It's jumping all over. It's not clear, and clearly the investigator was confused because the investigator says that person A is testifying, and in fact, it's person B. It's not clear who's testifying. It's not clear what documents they're talking about. There's extensive testimony about documents that are attached to our submission as Exhibit C and D, which are performance, I guess I would call them kind of incident report or performance notes that the pharmacy director took years earlier. And I believe the investigator conflated that testimony with testimony about the written warning, which is really the key document here. So I think that the reliability, I probably wouldn't be up here arguing this if it were just the fact that workers' compensation transcript was looked at. I still don't think that's really the best evidence, but it was really the fact that it was unclear, it was scattered, it was out of context. I think that's really the bigger issue.
I presume that the testimony that was offered in the workers' compensation proceeding was sworn, correct?
Yes.
Okay. And does that fact change your assessment here?
It doesn't change my assessment as to the unreliability in terms of the way it was presented. Again, if we had the full transcript and if questions about that transcript were asked at the fact-finding conference, I don't know that I would be up here solely making the same argument based solely on that issue. I still, again, don't think it's the best evidence. I think we have fact-finding conferences for a reason, I assume. It's so that we can ask people questions directly. So it's confusing to me why a question would not have been asked of Ms. I won't use her name, excuse me, the pharmacy director who's sitting there at the fact-finding conference. She was never asked, did you fill out this written warning after the fact and place it as personnel file? I don't know why that question wouldn't have been asked if that was a key issue. So I do still think it's a problem for that evidence to be considered, even though it's sworn testimony in another proceeding, but I think it's far more problematic in terms of the scattered and out of context and confusing, frankly, way.
I think I heard you say too that, we as a commission are not functioning or operating on this best evidence standard, right? So
sure.
To the extent that it's helpful, there's some assessment of, its probative value and reliability, that it could be something that an investigator appropriately relies upon. You'd agree with me there.
I think so on some level. I think the agency evidence, I mean, the due process standard for an agency action, I think is that the evidence is able to be sort of clearly understood. I'm maybe not articulating that as precisely, but it is sort of capable of being understood and is reasonably reliable. If it were an entire transcript, it's probably reasonably, I mean, that probably meets that standard, right? But the fact of how it's presented and we don't have all of it and we don't know what documents we're talking about or frankly even who's testifying, I think is what really makes it unreliable and confusing.
I also have questions for council. I don't know if you'd like to take those now or wait until.
That's up to you if you want to hear all the arguments on the facts first and then talk about jurisdiction, or we can do it now.
Do my colleagues
I would,
have
I
your
would, I
organization?
would wait, maybe, I'm sorry.
No, that's okay. I'm very curious, but go ahead.
I wonder though, you know, as Attorney Strader notes, the jurisdictional argument is a threshold issue. So if we don't do, you know, so my preference is to start there, but I want to be sensitive to.
I think you both want to have this done now, so I'll vote it.
Wonderful. Barbara, what sayeth you? The jurisdictional argument as Attorney Strader presents it is compelling and persuasive. So help advise commissioners on why he's incorrect.
I'm gonna say something I almost never say. I'm not sure he is incorrect. So what we have done, and the first time this happened was in 2019. And since then, on occasion, there's a snafu that has nothing to do with the parties and things get mailed late or overlooked. And I've done a ton of research, but only really focusing on making sure that we are not upsetting the rights of the parties by being late. And I can tell you that we're not. The parties can still go to court. Nothing would really change. We have always issued a decision anyway with this footnote saying, not the party's fault, so that if they decide to go further, that's what happens. I agree that the language says must. I agree that it's the same language that says that the complainant must file within 300 days. I have found nothing helpful to tell me whether that means we cannot issue the decision, which is always, I mean, the investigation always has been actually concluded. It just hasn't gotten onto an agenda or it hasn't been mailed out for whatever reason. So the answer is I'm not sure. And honestly, Dan's the first one to call us on it. And I would like the chance to do some research. I understand that there is not, I haven't been able to figure it out since reading this. But I will concede that it is entirely possible that we no longer can issue the decision. The other thing is we issued the decision because, let's face it, we don't have any actual authority, so it doesn't change anything. And the investigator's done all this work and the parties might want to take advantage of, say, conciliation afterwards. And so we do it to give people as many options as possible. But again, where a party is, this is the first time a party has raised it as a jurisdictional issue, and it's a good argument.
Yes, yes, it is.
So in terms of how we proceed today, then, in terms of issuing a decision, council is asking for a dismissal, basically, right? So what is your, do we table this to allow more time? What is your recommendation there? And maybe you need time to think about that while the complainant presents.
That's, well, I mean, you could hear, we could hear the arguments, and that way the only question would be.
Your video's on, you can turn it off. Oh, what do you mean? You can turn your video off?
Jane and Grace, you're both unmuted. Please mute yourselves.
Honestly, I'm not sure what I'm gonna find at this point, but I'm happy to try to figure it out. It would involve tabling this. And or you can hear the rest of the arguments and then we can table and just vote later if you think that makes sense since we've got the parties here.
Yeah, I'd
Um,
be in favor of
and
completing
then,
the hearing and then.
yeah, and then the only thing would be whether we can actually issue the decision or instead we turn around and AD it.
So you're saying, so you're saying here's the case, but not vote? Is that, and table it to another time and then vote? Is that what you're saying?
Yeah, I wouldn't want to vote because it has the potential for being an advisory decision that the parties don't want from us. Or at least the party who pointed this out does not want from us. So I think that we could, I mean, and maybe we ask the parties if they want to come argue again, or if they want to just finish up. I don't think that the fact issues are gonna really influence the decision. That's a purely legal issue.
I'm sensitive to the economy of time.
Yeah, exactly.
You know, we have other matters on the agenda to hear today as well. It strikes me as being more efficient to deal with this threshold issue first. We may not even need to have a discussion, right? Depending upon the result. We may not need to have a discussion about any of the factual circumstances here. I am sensitive though to the fact that the parties aren't here. And so I'm curious about if you have a preference for how you'd like the commission to handle this, and then we'll ask the complainant the same.
So it's especially awkward since we've already let the respondent argue.
Yeah, I gotta say, I think
Yeah.
my firm position is that we should complete the hearing and then sort of not issue a decision until we decide what to do. I think that's the right, I mean, council is standing right here.
Yeah, and
the complainant is here, let's
I
finish
can
the hearing.
figure it out, and if I decide we don't have jurisdiction, we can issue an AD before the next meeting, and otherwise we'll vote at the next meeting.
Respondents for you.
Sure, I guess my only point on that, you know, I did do the research. I don't think you're gonna find anything.
I don't either, but
Because we know it's Maine, right?
I would
There's a
like
limited
to
case
be,
law.
I would like to at least see if I can find something that answers the question.
I suppose, I mean, I would have, yes, I mean, to the extent that research hasn't been done for today, I guess, if we do that, I guess I would just ask that, if your conclusion is different than mine, I guess I'd like some follow-up opportunity to address it rather than just have that be the final word, would I guess be my
That's fair,
pushback on it.
that's fine with me.
Can we touch base with the complainant?
Yeah, please.
Understand his preferences with respect to how we proceed.
I would like to be able to speak it.
Okay, yeah, great, we'll do that. Thank you.
Want to step down?
Sure.
Do you have other questions on?
No, thank you.
Get you when you come in.
So Mr. Witt, you also have 10 minutes if you want to reserve any of your time.
I'll try to speak without stepping over the line because I'm not really, I'm not a lawyer, so.
To the extent you did, very gently. Prompt you.
I do have the document from the workman's comp. Obviously, I can't say, anything with that. Just to point out that the owner and pharmacy director also have the whole entire 200-page workman's comp thing. They had it right from the start. There's a lot of stuff in there that they admit under oath in front of Elizabeth Elwin,
Please
administrative
don't
law.
use the name of.
Okay. They admit that in front of the judge that a lot of the things that they did were done after I was suspended and terminated, especially my personnel file had very few pages in it. And then in the last couple of weeks and after I was suspended and terminated, it grew into 50 to 100 pages long. And all of those pages were fabricated after I was suspended and terminated. They weren't in there because I had never, the entire time that I worked for them, which was for 10 years, I had no signed written warnings. I had no incident reports, which is when you make a mistake. I had no customer complaints. I worked with 50, once again, maybe 50 and different employees. A lot of them long-term, never had a complaint from them. The only complaints that surfaced were in the last 2 weeks I was there. And they were from new employees, new pharmacy technicians that were hired and trained at the big store in Skowhegan and sent over to work with us. And I said during the hearings that I felt that they were watching everything I did. They were letting my bosses know what I was doing. And most of the things that they said that I did, I did not do. For example, letting the girl use the cell phone when there was no cameras. She came to me and said that her daughter had COVID, she needed to call her, or she had to go home if she didn't, which was an hour away, which means she would have been gone all day. And that she wouldn't answer the phone if it was from the pharmacy. Can I use my cell phone? And I, said, yeah, I guess so. You can use your cell phone, but please don't use it right out in front of the in the pharmacy. Go to the back room where there's no cameras. I admit I did that. I did say that, but that's the reason why I did it. They accused me of theft, stealing syringes. Once again, somebody came to me, prescription filled a few days before, the container was empty. What do I do? I mean, in a pharmacy, you literally make thousands of decisions in a day, every day. And it's not all pharmacy, it's personnel, it's everything. And so I went, got the syringes, 10 syringes, 75 cents worth, went down to a customer that was a long-term customer, took care of them so that they were happy, gave them the syringes that were not in the container. And once again, somebody watched that on a camera after I was terminated and suspended and said I stole them. I stole them. That's what they say. So a lot of the things that were said about me, I feel were wrong. I did say negative things about the pharmacy director and the owner. I admit that. We got 2 poorly trained technicians. They had a lot of personal problems. They missed time. I tried to work with them, and it was hard. And what had happened in the pharmacy, which that caused this whole problem, was the methylphenidate substitution. Is kind of why we're here. Is they were billing Maine Care for a certain brand of methylphenidate. And they were, which was the ones that were covered by Maine Care. They covered 2 brands, but they were putting a substandard, what I call a substandard pill, in the bottle. The pill was twice the size. The pill was loaded with dyes and fillers. It was something that should not have been dispensed. Maine Care did not cover that brand for a specific reason. So that's where all of this came from. Is I refused to fill these prescriptions, and the whole fall of 2021, I refused to fill them, and I had disagreements with my supervisor, the pharmacist in charge, and she basically said that I had to fill them that way, and I said I'm not doing that. I'm not putting my patients at risk. I'm not committing fraud against Maine Care and the drug manufacturers. And it's actually the federal government also, because they reimburse Maine Care for the medication. And we had that discussion over the whole fall. I asked her to bring it up with the pharmacy director, which she told me she did. One of the times I worked with her during the week. And she said that the pharmacy director said I had to do it their way. And if I didn't, I would be in trouble. And I told her I am not doing that. I refuse to do that. And I was also working every Saturday and Sunday. I was there by myself. I used the proper brand. I did not, I refused to substitute the cheaper generic. When we were in the pharmacy together with the other pharmacist in charge, who was my boss, he told me, and it's documented, again, it's documented, and this is actually from Pierce Atwood, wrote this response, that she told me that when those prescriptions need to be checked to go go do something else, and they got checked by her. And many times we had a discussion about on the weekends when I worked by myself, she said, you need to do it our way. And I absolutely refused to do that. And that's when things started to unravel for me as I get the target on my back is all I can say. It's how I feel. I refuse to follow along with those, what I consider illegal practices, and worst of all, put my patients that I've known, you know, a lot of children get the methylphenidate kind of prescriptions for ADD and ADHD, and I just refuse to do that. So, I mean, I feel, you know, in every business, you have the poster. I mean, you reported a violation of the law, and I feel that by putting the cheap generic in the bottle and billing the other brand was a violation of law. It was Maine Care fraud. It was fraud against the manufacturers. It made if you had a recall on medication, it makes it impossible to figure out what actually got put in the bottle. So, I mean, it's a total violation of the law. You know, you are a healthcare worker and you reported a medical error. Every single time that bottle went out, it had the Patriot NDC on it, the Patriot name, and the cheaper generic was put in that bottle. That was a medical error. Because a patient, if they're allergic to red dye number 6, and they got the brand at Maine Care covered, it was written on the bottle that they thought it was that, they did not have a problem. But when they get that cheap generic, it was orange. It was orange for a reason. It was dyes in it. So that was a medical error every time. Once again, you reported something that risks someone's health or safety. Every single time a prescription bottle went out, it said Patriot on the label that the cheap generic was put in that risked someone's health or safety. You have refused to do something that would endanger your life or someone else's life, and you have asked your employer to correct it. Every time I worked with my pharmacist in charge, I asked her and I educated her on why she should not be doing that, why the owner and the pharmacy director should not be okaying that, and training. The new technicians were trained to do that when they came over too, which immediately put an end to that, which caused a little bit of hard feelings between me and them. And part of the reason why I think the top, you know, some of the stuff that they said about me, they were kind of mad at me because I had to come down on them and make them do things right. So, and I asked her multiple times not to do it, or I refused to do it, that they should change what they're doing. And the only time it changed was after I made my pharmacy board complaint. And it says, you have been involved in an investigation or hearing held by the government. Yes, I did make a pharmacy board complaint after I had been suspended. Because I knew that I had no other chance then to change this.
That is your time.
Okay.
Any commissioner questions for Mr. Witt? Mr. O'Brien.
Hi, thank you. How long, you worked for them for a number of years. Had this issue been an issue for you, for them from the beginning?
No.
Okay.
I was a pharmacist in charge. I was promoted to pharmacist in charge. I stepped down from that because I could not work the amount of hours that was required to be the pharmacist in charge. When the new regime came in, they changed all the rules for pharmacy because we kind of ran the pharmacy before, and that came with it. You have to substitute. You have to bill Patriot methylphenidate, and you need to put in the cheaper generic in the bottle to save money for inventory reasons. Was their excuse? So it started in the fall, early fall of 21, when I was just a staff pharmacist.
Yes, good morning, sir, and happy new year. The complaint, you say that you received no sign warnings and so on and so forth. Respondent claims that you received a documented verbal warning on December 14 of that year, 2021, and that you refused to sign it. Is that true?
It is not true. That documented verbal warning was written after I was suspended and terminated, put in my personal file. And the reason that we have had a process where you got to document if you made a mistake, if you made a pharmacy mistake, or if somebody had a problem with you, you got to document. And you discuss the document. You discuss what you did wrong, why you made the mistake, what you were going to do to change it, and then you sign it. That you admitted that you did it, that you had been discussed it, that you would, what are we going to do to not do this again? That document actually could go to the pharmacy board too. So you made sure it was accurate. So that document that you're talking about there was fabricated after I was terminated with leave or suspended.
Okay. And I apologize. It's Monday. I'm a little foggy. You know, typically I would have prefaced my remarks with, we're just trying to sort of figure out what happened here based on the record, because there's some factual disputes here. Another issue is the business of the different names on the prescriptions, right? The different carriers. What the respondent says is that there was a conversation between you and Ms. Carrier, the pharmacist in charge at that time, about this practice, and you raised your concerns, and she said it was fine. Did that ever happen?
Yes.
Okay.
Yeah. She said it was fine. That that's what their policy was to do in all 3 stores that they had at that time, was to build a Patriot, which wasn't covered, which patients thought they were getting, and put the other one in the bottle. She thought it was fine. She did not understand how Maine Care rules. Maine Care. I mean, for 37 years I've been a pharmacist, I've had to deal with Maine Care. They have their own inventory that you have to literally keep in the store, and it costs the store money. It's a burden on it. It's a financial burden on the store, but that's the way it is. There's no way around it. You have to do it. And I can say in my 37 years, I never once billed one NDC, put another one in the bottle because I want to keep my inventory down. We're talking $100,000, $200,000 in extra inventory just to go Maine Care prescriptions. It's substantial, but you have to do it because Maine Care relies on those rebates from the drug manufacturers. So if you feel that Patriot company was paying Maine Care for the rebates for medicine that they thought was being used and dispensed to the patient, but in reality, it was not being bought at the wholesale level because they didn't use it.
Right, thank you.
Yeah, so certainly, you raised concerns protected under the whistleblower protection. Respondents' position is that, fine, and your employment was terminated for non-discriminatory reasons, right? So Attorney Strader on page 5 of his rebuttal lists 5 serious concerns related to your performance. And I think I understand your position with respect to those serious performance issues that he lays out, which is either it didn't happen or it's not fairly characterized here what happened, or there's detail and nuance that should minimize those concerns. Is that a sort of fair characterization of your response? Okay. Were you aware, in addition to those 5 concerns, that the technicians that you described at that point were, quote, so uncomfortable with Mr. Witt's behavior that they both asked not to work with him again, end quote? Were you aware of that concern?
Nothing was ever said to me. No one ever came to me, met with me, no phone calls. I was suspended with a text and terminated with an email. Not one person ever came to me and said, there's a problem.
If that were true, though, would you agree with me that that consideration would pose serious operational hardship for the pharmacy in terms of having staff. Yeah, so if you had 2 pharmacy technicians, right, which are required in order to run the business of the pharmacy, if those folks were no longer willing to work with you, that would create a serious staffing issue at the pharmacy, correct?
Yes,
And-
somebody would have had to come in, fill in for that.
Okay, thank you.
But they never spoke to me. They never said a word to me about being uncomfortable. I work.
Seeing none, thank you very much. You have finished your third time, I think, you have 2 minutes and 45 seconds.
Thank you. So there's a couple things. I don't want to get too into the weeds on the merits of the complaint that was made. It was protected activity to the extent he complained about it. I get it. It's a reasonable belief standard. I will say these are both FDA approved generic medications. We're not talking about giving anyone an unsafe drug. These were both medications, by the way, that were approved routinely by Maine Care. The issue was availability during COVID was poor. Availability of the Maine Care support staff to approve these preemptively was also delayed. There was not people able to answer the phone. So drugs were being dispensed. Approval was granted retroactively in, I believe, every case. So this is not, I mean, I think it's being painted to be something much more nefarious than what was actually happening. It was the pharmacy trying to help its patients in a timely manner and not give them a brand name medication that costs hundreds of dollars, and we've got a generic for $10 that's readily available. I also point out that the complainant admits, or I guess he hasn't, I should say, pointed out that there's any evidence that the decision maker here, the pharmacy owner, was actually aware of any of this protected activity. The pharmacist in charge, he talks about, he says it was fine. You don't have to do it. I'll do it. There's just really no evidence that this was an issue of concern for the pharmacy and that they were, oh, we need to silence this guy. And that the investigator's conclusion on that was incorrect. He stated that the respondent admitted that everyone sort of agreed he'd been making these complaints. So that's not true. The only person who knew about those was the non-decision maker, the pharmacist in charge. And I also point out that Mr. Witt has essentially admitted to virtually all of the conduct for which he was terminated. I mean, he has characterizations and nuance and all of that, but he admits bad-mouthing the pharmacy. He admits giving out these syringes without charging them. He admits showing people how to hide from surveillance cameras. I don't think it came up just now during his comments, but he did acknowledge earlier in the fact-finding conference that he was not initialing. I mean, he said it repeatedly. He didn't believe that you needed to initial prescription bottles in that way, but he'd been told repeatedly you need to do this, and had been counseled for medication error just a couple weeks earlier. I don't know quite what to do with the dispute now, I guess, that we have about the written warning. I thought his testimony during the fact-finding conference was really clear that he did receive that. He's now saying that he didn't. At the very least, we have a fact dispute. We don't have what the investigator found, which was agreement and respondent's admission that had happened. We don't agree that happened, and I don't think there's evidence that we've ever agreed that happened. So I think that's all I have to say about it.
Any questions? We've heard from the party, and we will next hear from Bob O'Shane, the investigator assigned to this case.
Morning, Commissioners. Just to address a couple of issues right up front, as the respondent's counsel has noted, there was a typo with respect to the year of the events happened in one of the paragraphs. Number two, also acknowledged was that the speaker at the workers' comp hearing was incorrectly identified as complainant's immediate supervisor instead of a higher level supervisor. And in this case, having examined that, and as respondent's counsel noted, if you've seen the transcript, it is difficult that the speaker's name is not alongside of the particular comments. However, in this case, the fact that it was a higher level supervisor admitting and acknowledging that there were documents added to the complainant's disciplinary file after the termination of his employment, if anything, made it a stronger case that it was not a lower level supervisor attempting to feed the file. It was someone that was higher up that decided to add additional information after the termination decision had occurred. To touch briefly on the jurisdictional issue, again, I leave that to others. But generally, I can say at the time that it was entirely my error.
That's Bob,
Okay.
it's not necessary.
Again, it was simply, I was away from the office for a particular time, and that's when that occurred. So just wanted to make sure that that was purely mine. With respect to the underlying aspect of the case, that it's undisputed that the complainant raised issue about something that I don't believe is in dispute, that all parties concur that this was an issue that he genuinely believed may have been an issue with respect to either safety or illegality. Whether or not respondent had a different take on that didn't change the fact there was no question here that it was a genuinely held belief by him when he made his report. There's also no dispute that, at least as of the time of discharge, that the employer and the decision makers were fully aware of his concerns and the fact that he had filed a complaint with the pharmacy board. Albeit it was true that at the time of the suspension that perhaps only his immediate supervisor was aware of that issue, there was no dispute that a day after he filed the complaint that the owner was made aware of it. So it is clear that at the time the discharge decision was made, that the employer was fully aware that he had filed a complaint with the boards, which raises the presumption that something occurred between the time of the suspension and the time of the discharge that changed his employment status. I have nothing else to add at this time. Again, for me, I was focusing solely on the reasonable ground standard, which was whether, based upon the evidence involved in this case, the complainant would stand a likely even chance of prevailing at trial. In this case, I have information that after the complainant was discharged, that additional disciplinary information was added to his file, that the employer was aware that he had filed a complaint with the pharmacy board, and that ultimately that was a factor in his discharge. So for me, that was enough to get him to the 50-50 standard. With the information that I had before me, that he had at least an even chance of prevailing based upon the fact that information was added to his file after he was discharged, and that he had raised a legitimate complaint just shortly before that discharge decision was made. I'm available for any questions, Mike. Yes.
Yeah, I'm curious about this. So this disciplinary warning document dated 12/14/23 added after his termination. I'm curious though.
Yeah.
The rationale, right, the information laid out in that document, that was known to management at the time, correct?
Agreed. There had been no dispute here that there had been years where he had been, I don't want to say insubordinate, but was selective with respect to certain practices that he had.
So,
However, prior to the suspension, those had all been dealt with as part of the normal course of employment, that it hadn't led to any type of discipline in the past.
so if those reasons documented in that letter were in fact, right, that comprised the rationale for termination, why does it matter when that document is added to the personnel file? Why does it matter? When that
I guess for
document
me it
is
was
on the file?
certainly, I think in this case was also the fact that the employer admittedly never discussed any of these issues with him or gave him a chance to respond prior to the discharge decision. That one would assume, number one, they admit that they skipped the progressive level of discipline that were part of their policy. And number two, never even bothered to confront him or to ask him about these alleged events. While some of them were on video and may have somewhat spoken for themselves, for a 10-year employee, never to be given a chance to even provide his side of the story before the ultimate discharge decision, just seemed to me that they were moving pretty quickly towards this decision. So it was the motivating factor. And as the motivating factor, I had a pharmacy that had just been nailed with a complaint with the Board of Pharmacy that made this decision without even asking him to provide his side of the story. So again, for me, that was, I don't want to say suspicious, but curious enough that it felt like there was something else at play aside from simply responding to two brand new employees' criticism about how their boss was behaving.
So that assessment, right, presupposes that these, 5 bulleted items that respondents describes in his rebuttal are not serious enough, right, in and of themselves to justify termination.
I don't know whether I would take that ultimate step. I think certainly there were things that were legitimate concerns. I think the complainant admitted at times that if he was the only pharmacist on duty, that he didn't see the purpose of having him formally sign the prescription. It was clear from the records exactly who had done. So whether or not there was a decision to save time, whether or not it was done for some other reason, these were things that have been known to the employer for a number of months, if not years, that were not acted upon. So whether or not, and I think for me also, it was that at the workers' comp hearing, the higher level supervisor was asked directly, after you had made the decision to terminate him, you then created these documents to support the termination, correct? These notes did not exist at the time you made the decision to terminate, correct? So for me, again, it seemed as though if they had a legitimate reason to terminate his employment, that there would be no need to go back retroactively and add additional evidence to the file to support that decision. So I found that troubling as well.
I want to talk about this all morning, but I just want to understand. I'm looking at your factual findings, right? And in particular, paragraph D, where you say, pharmacy asserted that the second incident, refusing to review an initial prescriptions, this is a safety issue, etc. Pharmacy asserted that the second incident led the pharmacist in charge to issue complainant a formal written discipline warning. December 14. Complainant disputed this, claiming he had never been issued any documented discipline that he signed over his 10 years of employment, although he did acknowledge receiving a copy of the December 4 incident report regarding communication error. And so my question is simply, did we ever see this December 14, this alleged written warning as part of the record?
It is part of the record. Again, and I think complaint was somewhat playing semantics by saying that he had never received any document that he signed, when in fact the December 4th document he did not dispute was presented to him, and that issue was in fact discussed with respect to dispensing a different dosage of a particular medication. The December 14th one that outlined the other incidents, he disputed ever having any conversation about that document or being presented with it prior to the discharge. So the December 4th one, there's no doubt. The 14th one, it's unclear whether or not that was specifically one of the post-employment created documents or not. But again, there is nothing on that form that indicates that complainant was aware of those concerns.
And then on the two different drug names, right? The prescriptions themselves. So far as I read it, you correct me if I'm mistaken. The record says that basically he had a conversation with his supervisor once about this. He made his concerns known, and the supervisor said that's fine, right? And then he files this board complaint after he's suspended. Am I missing something? Is there anything else?
No, I don't. I think it's the question whether or not he may have been partially motivated by that latter conversation to formally file a complaint with the board. Again, but the idea that somebody is saying, we understand that you believe this may be illegal or unsafe, so I'll do it next time, doesn't really allay his concerns about whether or not patient safety is being protected. So again, the fact, I guess, would be akin to somebody in the store saying, I see people shoplifting, and a supervisor says, don't worry about it, we'll take care of it. isn't necessarily going to take care of the concern simply because he's not a direct participant. I just think that there's been no evidence presented that he was in any way had some other ulterior motive here, aside from the fact that he was concerned about the legality and the safety of the patient. So as I say, whether or not somebody said, don't worry about it, you can look the other way, didn't really change the fact that he was raising legitimate concerns. And I don't think respondent has been heard to argue that his concern, it may have been less warranted than what he believed, but nevertheless, there was no discussion here that he was doing this for some ulterior motive aside from patients.
Just to wrap all this up.
Yes.
My understanding of your sort of position conclusions here is simply that regardless of how all this went down, when they actually terminated him, they did have notice of the board complaint.
It did. It was literally pending at that time and had been so for approximately 10 days, I believe. So whether or not the initial suspension was motivated by it, again, is subject to scrutiny about whether one believes that his immediate supervisor would never have discussed this with higher up. Again, we have no evidence supporting that that occurred, but certainly at the time of the discharge, there was no doubt everybody knew that there was a complaint pending.
Thank you.
From the parties and the investigator, if I understand our discussion at the beginning, we are not voting on this right now. We're going to wait. I probably should have a motion to sort of put this on hold until, let me finish my sentence because otherwise I won't remember. Put this on hold until Commission Council has had a chance to look into it. At the very latest, we would be hearing, I imagine, something about this at the February meeting.
If I have any time left, am I permitted to respond at all?
No, at this, unless I have summarized that incorrectly, you're welcome to, all of the parties are done with their time for argument.
Sure.
But unless I have not summarized that part correctly and you remember something else better, because I'll admit that it is Monday morning for me also. Entirely possible that I got that wrong. Have I summarized that correctly as far as everybody remembers? Okay. What I think, because these are public meetings, is that we can't really have a decision on this until the commissioners reconvene in February. If it is an administrative dismissal, I think I would still at least want to bring it back. Parties are welcome to participate online instead of coming all the way to Augusta for that, as all parties are. But I think we would at least want to address what the decision is at the February meeting. Yes. Okay. So I think what I would like. Yeah.
So would the arguments be presented again?
No.
Okay, no, all right.
But I understand that Attorney Strader, if we decide we do still have jurisdiction, we would then maybe have an opportunity for the parties to be heard on that issue, not on the factual issue, but just on the jurisdictional. So what I would like is, I think, a motion to table making the decision on this case until the February meeting.
So moved.
Second.
Okay, any further discussion?
Can I ask a point of clarification?
Sure.
So understanding that the intent is that we would come back in February after Dr. Hirsch has done some research and we'll see kind of where the jurisdictional issue stands. And I think the outcome would be either council agrees that with my position, or there's some counter argument made. Would that counter argument be provided in any way in advance, and would there be a written memo of some kind that I can anticipate, or do we anticipate that would just happen at the?
No, I think we would need to give the parties some notice one way or the other.
Thank
So
you.
I would think, Chelsea, you don't happen to know off the top of your head what the last date is for submissions for the February meeting, do you? Looking at the agenda, the latest date that I see on there for sort of parties to make a submission of disagreement is January 21st. So I would anticipate that you would hear from us one way or the other sometime around that date, if not before.
Okay, thank you.
Okay, it's been moved and seconded. Any other discussion? The motion is to table the vote one way or the other on this matter until the February 10th meeting. In an agreement, you will vote yes. Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Ed, could we take 5 minutes?
Sure. We'll be in recess for 5 minutes.
I know what it's. Okay.
Well, it's.
Okay, we'll call the meeting over again. The second case for hearing is Z 23-008 Hector Gomez versus Alcom LLC. It is a recommendation for findings of no reasonable grounds on both counts, and therefore we would hear first from complete.
Okay, is there anybody here for Mr. Gomez? Oh, yes, so apologies to everybody. The agenda in the room is incorrect. McClendon has been tabled until February. The agenda that is online should be accurate, but I think this got printed before that happened. So, is there anybody here for Hector Gomez?
But finding none, I'll make a motion that we find that there's no reasonable grounds to believe there was unlawful discrimination on the basis of race, nor on the basis of retaliation for protected activity.
Not even gonna try to call that one. Okay, so. Alex. Thanks for coming. And goodbye. Of course. So it's been moved and seconded to find no reasonable grounds because complainant is not here. Any discussion? Being none. The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Alexander.
Yes.
Yes. Findings are no reasonable grounds. Attorney Finberg, thank you for being here remotely. And the commission will send a letter to the parties and the council confirming the results of the hearing.
Third case for hearing is E23-0313 Keith Holland versus Piedmont Airlines. It's a recommendation for a finding of reasonable grounds. Therefore, we will hear first from respondent.
Good morning. Yeah, good morning. This is Dan Farrington on behalf of Piedmont Airlines.
1 minute, Attorney Farrington, will we pin you on the Zoom? There you go. Okay, great. You have 10 minutes. Do you want to reserve any of your time?
Is Mr. Holland present?
Yes, I am.
I'd like to reserve 3 minutes, please.
Whenever you're ready, go ahead.
Thank you. Good morning and Happy New Year. Our objection to the report and recommendation is based on the fact that the alleged harm lacked materiality, and as a result, there was no adverse employment action. Piedmont employs the complainant as an agent in Portland. Mr. Holland's religious beliefs prevent him from working from sundown on Friday until sundown on Saturday. Among the responsibilities of agents are security-related overnight searches of aircraft that are parked at the airport overnight. New agents are trained as a group in a one-time training. The training was scheduled for March 30th and 31st, which was a Thursday and Friday evening in 2023 for the complainant as well as the other new agents in his incoming class. The complainant attended the Thursday night training, received his training. He did not attend the Friday night training, but was assessed dependability points under the attendance control program. That's what we're here about, or that assessment of points. It did not come with any economic consequence. The complainant did not lose wages, did not lose benefits. He has since passed his probationary period. He continues to work for the airline. He has sufficient seniority to bid schedules that avoid shifts that conflict with his religious practices. And so there are no ongoing problems. The absence of an adverse employment action in this case is demonstrated by the fact that there is nothing to remedy. There was no loss of pay or benefits or any other economic loss. The dependability points at issue have, by virtue of time, long since rolled off of his record. So there's nothing to remove from his file, as it were. And he's had no additional conflicts between his religious practices and his work at Piedmont. So there's no ongoing problem to remedy. And so, but before I close, I do want to note that the investigator cited to the King case to note for the proposition that an abusive reprimand could constitute an adverse employment action under the Maine Human Rights Act. That's a case that's more than 30 years old, and the facts are distinguishable. That's a case where an employee in a credit union had a medical condition that rendered her highly susceptible to secondhand smoke. This is back when people still smoked in their credit unions. And she asked for an accommodation, and her supervisor told her that if she needed to be accommodated for that disability, then she should look for another job. And so the reprimand in that case was an overt threat to Ms. King's employment. It's highly distinguishable from the routine application of attendance points under a dependability control program. And I'll also note that no court has cited to King since the case was decided in 1992, I believe, to find that an immaterial action is enough for a viable employment discrimination claim. And then the one thing I finally want to note is the investigator, and this is essentially an apology to her, the investigator had a footnote in her report that suggested that we obfuscated a little bit in response to her questions on whether Mr. Holland attended that Friday night training session. There was some miscommunication between us, and I do apologize if she thinks that we were obfuscating. That's certainly never our intention. I think the facts of this case are relatively straightforward, and it's really a purely legal question that you're presented with. I thought that she was under the mistaken impression that Mr. Holland was required to work that Friday night in violation of his religious practices, when that wasn't the case. So to the extent that I misunderstood the question, or my response came across in a way that suggested I was obfuscating, I do apologize to her, and I'll reserve the bulk of my time.
Before we take questions, I just want to note that we are out of order from our agenda. I think we're taking the cases in the order in which they are listed in the drive file. So we should have heard LaMontagne next. We'll hear that after this case. Okay. Just so everybody's not confused, we're not skipping it. It hasn't been tabled. It's still on the agenda. We're just having a Monday. Yes, Commissioner Sanders.
Thank you, Attorney Farrington. I appreciate your materials and appreciate you being here today. As I was reading the investigator's report and your response to it, it struck me that, from my perspective, there are really at least two things that are material here with respect to the complainant's employment. So I want to articulate what those are and then get your response to those. So thing one is the extension of the probationary period, right, by application of the punctuality points or the point system. Didn't that delay then the complainant's ability to bid for shifts that he wanted that were more favorable, right? That he wouldn't have been entitled to do if he was still in a probationary status. So that's question one, and I'll lay out the sort of material fact number two, and then have you respond to both, if that's okay. So thing two was, by extending his probationary period an additional 30 or 90 days, whatever it was, doesn't that therefore mean that he is then not entitled to just cause protection under the collective bargaining agreement? And isn't that a material outcome, right? So he remains in a probationary status as an at-will employee, and therefore doesn't have the full rights and entitlement and benefit of the just cause protection under the CBA.
Yeah, thank you for the questions. I think the answer to both is similar, which is the threat of a harm is not a harm, right? So this is a different case if the complainant, by virtue of having his probation extended, ran into a conflict with his religious beliefs during that extended probationary period. It's also a different case if during the extended probationary period, something happened that resulted in the complainant being terminated in a way that lacked protection under the CBA that to which he would have been entitled had he been deemed to have passed probation in that first probationary period. So my response would be that that those things didn't happen. So during the extended probationary period, and the investigator notes this, and I think it's footnote 3 to her report and recommendation. Technically, probationary employees aren't allowed to trade shifts, but as the investigator noted, the complainant was allowed to trade shifts during the second probationary period. And then likewise, nothing happened during that second probationary period, or since then for that matter, that brings the just cause versus at will standard for his termination into play. So I appreciate the question. I think it's a different case if the threat of harm that could have resulted from that extended probationary period actually happened, but a threat of harm is not an adverse employment action.
Commissioner questions for Attorney Farrington. Commissioner Davis.
Attorney Farrington, do we know when he was hired, what date in relation to when the trainings were offered?
Yeah, I could find the precise date relative to the training. Tell me if this answers your question, however, it was the first training for that new probationary class. So the trainings are only conducted as needed for new agents, new classes of agents. Does that answer your question? Are you looking for a specific
Okay,
time
so the
period?
trainings are scheduled ad hoc when you have a class
Right.
of new employees. How did he get the second? I guess the question is, are both sessions required? And if so, how did he get the second session?
Yeah, so this was somewhat of an unusual training because the individual who was conducting it was conducted by someone who had not conducted aircraft search training before. And so she scheduled it for 2 consecutive nights, and they have to be done at night because that's when the aircraft are parked. Otherwise, aircraft are coming in and out of the airport, and the agents are busy performing their other duties. So this was somewhat of an unusual situation in that it was scheduled for 2 nights. The complainant completed what he needed to do on night 1, and so there was no additional training that was required.
Can I say something? We will have an opportunity.
Yeah, and look, I am accepting for purposes of today's discussion that the attendance points shouldn't have been assigned, right? But what I'm saying is it's a foot fault, and it doesn't rise to the level of materiality, and there's no ongoing problem.
Oh, okay, but that's different from saying that he wasn't required to make that second training, that he fulfilled the requirements in the first night.
He fulfilled the substantive requirements. All of the agents were expected to attend both nights of the training.
Thank you.
Any other commissioner questions for Attorney Farrington? Being
Yeah.
none, you'll have about,
Sorry.
oh, yeah, Commissioner O'Brien.
I'm sorry. If you can, the classes or the trainings, are done when there is enough trainees. How many? Do you know that? How many in a group? And are they always scheduled on a Thursday or Friday?
I don't know the answer to the first question, and I don't know when the subsequent aircraft search trainings were scheduled. There's no reason for me to think they're always scheduled on a Thursday, Friday.
And the investigator is saying that that is not correct. Any other questions for Attorney Farrington? Okay, you'll have about 4.5 minutes left when we come back to you, Mr. Holland.
Yes,
You next.
so
I just wanna, you have 10 minutes. Do you wanna save any of your time to respond to what?
if I have a couple minutes left over at the end of what I have to say, then I'd like to reserve that.
And I can actually provide some answers to the questions you just asked too. Good morning, everyone. I'd like to thank everyone for this opportunity to address the commission. I believe my case is quite simple. I'm a Seventh-day Adventist Christian, and I believe in keeping all 10 of God's commandments, including the fourth, which states in part, remember the Sabbath day to keep it holy. For 6 days you shall labor and do all your work, but the seventh day is the Sabbath of the Lord your God. On it you shall not do any work. Since in biblical times, each day of the week began and ended at sunset, I'm convicted that I must not work from sunset Friday to sunset Saturday. Even before I applied to work at Piedmont Airlines, one of my friends who works for another airline questioned Bobby C. Lowe, who did my interview.
Please don't use the names of the.
Oh, I'm sorry. The Piedmont administrative assistant, who is responsible for doing most of the job duties. She questioned her regarding the feasibility of being able to get off work on the biblical Sabbath. And she was told that Piedmont could accommodate. When I went to my job interview, I asked the administrative assistant myself, and she too stated that Piedmont could accommodate my religious convictions. However, about a month after I started working there, I was scheduled for a training shift on a Friday night. When I requested that single training shift be rescheduled, to my astonishment, that simple and reasonable request was denied, citing a completely irrelevant portion of Piedmont's collective bargaining agreement with their labor union CWA that dealt with the filling of vacancies of all things. I still have yet to hear any explanation from Piedmont's attorney or human resources staff as to how their decision had anything to do with that section of the collective bargaining agreement. Even attorney Jeffrey Young, who, I guess you probably don't want me citing names, but the representative for Piedmont's labor union in Maine agrees that there was nothing in the collective bargaining agreement that would prevent Piedmont from rescheduling a training shift, since shifts are scheduled at the sole discretion of management. Furthermore, the Maine Human Rights Act specifically prohibits any contract between an employer and a labor union that has the effect of discriminating against a protected class, regardless of intent. Nevertheless, Piedmont Airlines deliberately defied the law and punished me with a 90-day probation extension, during which time I was not allowed to call out, even show up late to work for any reason, and I could not trade or swap shifts without the approval of a manager. They also gave me dependability points that imperiled my employment if I needed to call out even after the end of my probation. As a result of that decision, I was subjected to harassment by my coworkers, and I was forced to come to work sick. On at least one occasion, I had diarrhea so bad that when I was assigned to run bags of baggage claim, I had to inform my supervisor that I wasn't sure if I could make it to baggage claim without having to park the tug and make a mad dash for the bathroom. As if that wasn't enough, Piedmont's idea of an accommodation was to force me to bid while still on probation in order to manufacture an excuse to terminate my employment and blame it on their collective bargaining agreement, since I would likely be assigned a shift that would conflict with my religious beliefs and be unable to trade or swap it with coworkers.
normally probationary employees have their shifts assigned by management without any bidding involved, and the assignment of such shift is not regulated by the collective bargaining agreement. So even under federal law, Piedmont would be obligated to accommodate, although my Muslim coworkers have told me that they often don't allow them to attend Friday prayer services, even while they're on probation. As my job with Piedmont Airlines was only part-time, I had planned to spend much of my time and energy running my photography business after my probation period was over, but Piedmont's refusal to make reasonable accommodations for my religious convictions crippled my photography business and cost me thousands of dollars because I was unable to schedule photography events several weeks in advance. As you're probably aware, I had to attest to the truthfulness of my complaint under penalty of perjury and have it notarized. Yet Piedmont has consistently been dishonest about even the basic circumstances surrounding the case. Their excuses have frequently contradicted their own personnel documents signed by their managers. On one occasion, they said that I was punished for absences in May of 2023 that were due to being unable to find coworkers to trade my shifts with, even though their own personnel records show that I was never absent during the entire month of May, and the incident in question occurred on March 31, and it was a training shift, so I couldn't get a coworker to cover it for me, even if I had been allowed to trade shifts. Then they claimed that I was not punished for my absence on March 31 because I had completed my training the night before, but again, their own personnel documents say otherwise. These are just two of many instances in which Piedmont lied to the Maine Human Rights Commission regarding the circumstances of my case. Now Piedmont is claiming that because they didn't fire me or decrease my pay, that there is nothing to remedy and my case should be dismissed. I hope you can tell by now that this claim is equally absurd. Piedmont's decision to deny my request to be trained at a time that did not conflict with my religious convictions was a significant setback to my career and was clearly illegal under both Maine and federal law. Their incoherent and absurd excuses clearly demonstrate a pattern of contempt for the law, and it is imperative that they be held accountable for their actions. I might add that many of my coworkers have had similar problems. Other Christians who worship on Sunday have had difficulty getting off work on Sunday morning to attend church, and Muslim coworkers have had trouble getting off work on Friday to attend their morning prayers. I trust you will do all in your power to ensure that this type of blatant defiance of the Maine Human Rights Act is not permitted to continue unchallenged in Maine, and that people of all faiths will be able to worship according to the dictates of their conscience without being punished by their employers. Thank you.
Questions for Mr. Holland?
Yes, good morning, Mr. Holland, and happy
Yes.
New Year. Yes, so I just want to focus you in on what's at issue today, right?
Right.
So you've said a lot.
Yes.
Really what I hear council saying is that the sole thing that they appear to be arguing at this point is the reason why your claim might fail is that you didn't suffer an adverse employment action. He's described that in his submission for you.
Mhm.
So I just want to make sure I understand what your argument is in that regard.
Yes.
I've heard you say that as a result of you know, the scheduling, the reschedule, you had an extent and the dependability points, all this, you had an extension of your probation, right?
Right.
And you said that you've been harassed by your coworkers.
Yeah, so
Wait, just.
I'll let you finish.
Hold on.
Sorry.
Did you describe this harassment by coworkers to the investigator in this case? Is that in the record anywhere? 'Cause I don't see it in the report.
Investigator O'Reilly is saying no.
Okay. Okay. Just trying to clarify where we're at here. And then, you know, I think everybody's testified about the inability to swap shifts. Is there anything else? I mean, maybe let me ask it in a more focused way. How are you doing there? Are you still working there, right?
I'm still working there, yes.
All right. How are you doing there now?
It's, everything's going okay at present. Usually, when there's like a bid that comes out, I'm able to select shifts that don't, only shifts that don't include Sabbath hours. Occasionally, there might be some situations when I might have to select one of those, but usually I don't end up with it. But as a general rule, I would say that at least the majority of the time, I am able to select all shifts that are acceptable.
So we're able to swap shifts. You
Yes, I
haven't
am able to swap shifts now. Yeah.
been demoted, experienced a reduction in pay or any of these things listed in council's submission.
Right.
True?
Yes, that I haven't had any reduction in pay. I don't remember what all was mentioned.
I feel like you've been denied any opportunities for promotion or advancement.
I do not.
Oh, thank you.
Your question. Commissioner David.
Colin, I think we heard that you never had to take the second session.
That is not true.
You did have to.
Yeah, I did. They rescheduled it. I'm trying to remember the exact date now. It was sometime in April. And it was a few weeks after that. And they actually had to have several other employees that hadn't been trained in the 2 nights that they had to have some of them come back and take that training with me. And
It was about a Thursday night.
I don't remember which night of the week it was. I want to say it was like a Monday or Tuesday night. It was earlier in the week.
It wasn't Saturday.
No, it wasn't. No. They did reschedule it at a time that was acceptable for me. And like I say, there were a number of other employees that had to attend because they hadn't been able to complete it in 2 nights. Yeah, so my employment started February 28th. I remember someone asked that question. And the date of the incident in question was March 31.
February 28th month.
Yeah.
No, I don't know. Thank you.
Okay.
You'll have about 2 minutes and 50 seconds.
All right.
Attorney Farrington, you have 4.5 minutes left.
Thank you. I don't have anything additional. I'm happy to answer any questions that the commissioners have coming out of Mr. Holland's presentation, but I don't have anything additional.
I have a question for council before we let Attorney Farrington go. Do we need to understand something about a collective bargaining agreement, which is beyond my?
Yeah.
You do not.
I do not. That's what I wanted to hear. Thank you.
Well, can I just speak to that very briefly?
Sure. Do you think?
Yeah. So.
Something?
Yeah. Well, I ultimately it's not an issue. So because the case is focused on the dependability points that were assessed for the training session on March 31st. That's the case. The collective bargaining agreement would have only come up had if the claim had been about adjusting an agent's bid schedule after the fact. The case law is clear that a bona fide senior, that an employer, it is not a reasonable accommodation for an employer to violate a bona fide seniority system to grant an accommodation. So that comes up sometimes in religious accommodation cases in different scenarios. In this scenario, the complainant has sufficient seniority, as he articulated, to bid and hold a schedule that avoids conflict with his religious beliefs. So it's not an issue here in this case.
You initially told me in the first round of questioning that he wasn't required to take the second session, that he completed the requirements in the Thursday night. And that seems significant. And he's saying now, well, I want to ask the investigator if it's in the record, that he was required to take that second night with another class a month later. And obviously somebody in the company gigged him by putting in the disability rating for missing that Friday night. Right?
Yeah, the attendance points for missing the Friday, March 31st, 2023 were assessed. That's why we're here. I was surprised to hear Mr. Holland say that he later completed the training on an additional night. That's not consistent with the information that I was provided. I otherwise have no reason to disbelieve him, but the fact that it was scheduled on a night that doesn't conflict with his religious practices would I suggest would make that an immaterial fact.
Great, thank you.
Yeah.
Any other commissioner questions for Attorney Fairman? Seeing none, Mr. Holland, you have 2 minutes and 50 seconds. If there's anything else you'd like to add, you're not required to use it if you feel you've said everything you want to.
All right. So one thing I think the collective bargaining agreement was an issue primarily because they brought it up as a pretext to deny my request for accommodation. And I would like to point out that Maine law differs from federal law a little bit in that in definition of discriminate, it says, if I can find it, participating in a contractual or other arrangement or relationship that has the effect of subjecting a covered entity's qualified applicant or employee to the discrimination prohibited by this act. A relationship includes a relationship with an employer or a referral agency, labor union, an organization providing fringe benefits to an employee of the covered entity, or an organization providing training and apprenticeship programs. So that's my take on that. Federal law, there's some case law and whatnot that, but this is a relatively, I believe this was updated relatively, in the last 5 years or something. And I don't believe there's any relevant case law in Maine pertaining to that issue. So that's, that's likely not particularly relevant to some of the issues that we're dealing with today anyway. And yes, I did have to attend the other training session in April. And I wasn't actually scheduled to work a night shift until the end of May, as I recall. And so there was opportunity for me to attend another training if need be. And so it's not like they had to schedule a special training just for me. And this is all information that I submitted in my original complaint, like in 2023. Yeah, I think I've pretty much laid out all these details, and if anybody has any questions, I'm happy to answer them.
Further questions?
All right.
We've heard from the parties, and next we'll hear from Juno, the investigator.
Good morning, commissioners. As Skip said, I'm Jane O'Reilly. I was the investigator on this case. I think I'm just going to focus in on the specific issue of this case. From the commission's perspective, this is a very sort of straightforward single issue. There was an event that occurred, and my analysis was that that event resulted in an adverse employment action. So I want to talk about what my analysis was in the report, which includes a denial of reasonable accommodation, which neither party has really brought up or focused on today, but really it wasn't just the assessment of the dependability points, but the assessment as a direct result of a denial of a reasonable accommodation request, which is also part of the adverse employment actions in this case. So you have an employee who's hired who discloses police that require an accommodation, makes a formal accommodation request, is told to make that request in writing, does so, and that request is denied without a sufficient reason. That analysis is on, discussion of that analysis is on page 3 of my report, in the paragraph the second paragraph. Basically, that respondent at no point provided a sufficient argument for why, at that point, when he made that request to change his training shift, why that would pose an undue burden. And then furthermore, when he then didn't appear for his shift because it would violate his religious beliefs, he was assessed those 3 dependability points. I also would say that the footnote 5 on page 2 that discusses sort of what an adverse employment action is, how it's defined, how terms and conditions are defined under the Maine Rights Act. My reasoning under that was that even though he wasn't assessed a pay decrease, even though he wasn't assessed, that basically he was punished solely because of his religion, right? So he got the assessed points, then he was sick and was unable to attend work. And that pushed him over the point allocation for extending probation. If he had been sick and not been a member of a particular religion, been denied this accommodation, he would not have been pushed over that probationary period. So as a direct result of his religion, with no sufficient argument from respondent as to why he could have avoided that punishment, and I do see it as a punishment, then he would not have suffered that extension of his probation, which I do see as an adverse employment action. He was denied certain benefits non-probationary employees would have gotten had he not had to extend that probationary period. And I'm happy to answer questions.
Jane, you just said that they didn't respond to his request for an accommodation?
They did respond, they denied it.
Oh, they did respond and they denied it, but without a reason.
The reason they gave was that it would violate the collective bargaining agreement, and the portions of the collective bargaining agreement that they cited were seniority and I think, hold on.
It's filling a vacancy.
Mr.
Sorry.
He is correct. And filling the vacancy. So that was, the attorney for respondent referenced my footnote 7, talking about his response to request for information. And that's really what I was asking about. I was asking, why couldn't he be rescheduled for a training shift? The only responses I was getting was either he wasn't required to be there because he had finished his training shift, or some other answer that was not a sort of furthering of that argument. Why was this reasoning that was provided by respondent an undue burden? Why was this training shift being changed an undue burden on respondent?
It certainly seems to me that it's an adverse employment action. I don't have any problem with that. All we had to do was not assess the points, right? And it would have been a de facto accommodation, and he takes it 2 months later. Thank you.
Commissioner O'Brien.
Attorney Farrington mentioned, used the term several times, and that's again, not an attorney, in the room. Is that a legal standard, and can you speak to that? Do you see that that's
What standard?
I'm sorry, that the threat of harm is not harm.
So the legal language that he's referencing is in footnote 3, this idea that a terms and conditions of employment does not have to result in is not limited to things that have an economic or tangible impact. And the example that's used in that citation is like after your 5 years, most people are promoted. It's not written in stone, it's not a policy, but you're passed over for that promotion. If you can show that there's some sort of pattern in your employment that you're denied that has an effect on your employment, in this case, if you weren't promoted, you obviously wouldn't get that increase in pay, those increase in if you wanted that promotion. So what we're looking at are things that affect not just something like I'm getting paid less, right? They took money away from me. But in this case, the extension of probation, which would be, again, you can decide if you think, like I said, he's doing this, you can decide if you want, sorry, Commissioner David. If you see that as an adverse employment action, but my analysis saw that probationary employee versus a non-probationary employee, that probationary employee is at a has less employment benefits than that person who has passed that probationary period. So by extending him, you're putting him, comparatively against other employees at a lesser position.
Any other questions for Investigator O'Reilly? Yes, Commissioner.
Just briefly as possible.
Yep.
Difference between a probationary and non-probationary employee, right? We've heard about the inability to swap shifts. What else was there? What's the difference?
It's, sort of the dependability points extension threat of, I mean, I don't have a listing of like what probationary benefits are versus non-probationary benefits, but basically you don't become, they do talk about how, the CBA doesn't apply the same, the rights under the CBA don't apply the same to probationary employees, and I can't speak to exactly how that's functions out.
But it was your sense from your investigation, they're at a lesser status under the CBA.
Yeah.
Make a lot of sense.
Yeah.
All right, thank you.
Okay. Hope that was fast.
So fast.
Any other commissioner questions for the event?
Thank you so much.
Heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding.
I would move that the commission find that there are reasonable grounds to believe that Piedmont Airlines discriminated against Keith Holland on the basis of religion, and that conciliation should be attempted in accordance with 5 MRS section 4612 sub 3.
Second.
It's been moved and seconded. Is there any discussion?
Yeah, I mean, I just wanted to say that when I originally read the materials, I was thinking, as Attorney Farrington basically is arguing, that it was no harm, no foul, but clearly that's an adverse employment action. I can create a scenario in which that training is legally required and has to do it, and would make the issue a lot closer. But he's working for a month. They're letting him go for 2 months without taking the second training, but they give him those dependability points, and that's an adverse reaction. That's an adverse action based on his religious request for accommodation.
Yeah, I'll just add to all of that. I'm just going to add to that I've been convinced by the testimony that, I think we narrowed down the adverse employment action had to do with the extension of probation, but I think that, that extension basically kept him in, it was like a subclass of the whole means, which I think that qualifies as adverse employment action. So I appreciate the arguments made by Attorney Farrington. I think those are well conceived and well presented. But I think there was an adverse employment action in this case.
And simply too, as Investigator O'Reilly notes, the simple fact of the denial of the request for the information without meeting that undue burden standard, that in and of itself, right, is an adverse employment action.
I just want to say that, Jane, thank you for being here in person, and I would have said that to Shane also, but.
And Alex was here. Alex is here too, even though their case wasn't heard.
Well, I was going to say, if the case was heard, thank you, Alex.
All right. Any other discussion about where we were for a minute? Seeing none, the motion is to find reasonable grounds. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay, so the findings are reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing and letting you know what the next steps are. Now, we will go to La Montagne.
Excuse me, may I be excused?
Yes, absolutely. Thank you for being here.
Thank you for the opportunity to be heard.
So I don't know how I got
The agenda
I
is.
thought I was on line, but the next case for hearing will be PA 230132, Sarah LaMontagne versus the State Board of Social Work. The recommendation is for a finding of no reasonable grounds, and therefore we'll hear from complainant.
All right, Ms. LaMontagne, you can unmute yourself. You have 10 minutes. Do you want to save any of that time?
I am going to try to save about 3 to 5 minutes.
Okay. I'll start you off with 7 and let you know when that runs out, okay?
Thank you very much. Again, I really appreciate the time to make an oral or argument and presentation. As a patient under the purview of a therapist licensed and regulated by the Maine Social Worker Board, I was denied the proper treatment for my gender identity issues due to the Maine Social Workers Board refusal to discipline those under their purview. The Human Rights Commission currently has accepted, without evidence that I can see, I've read the commissioner's report, I've tried to find any public reference to this, but without evidence that the Maine Social Worker Board dismissed 66 of the 93 complaints that it has resolved. That amount, again, to me, seems to indicate that they don't, believe in disciplining, and that they're basically aiding and abetting therapists to do basically whatever, that they choose, to discriminate, to treat mental health, another protected section under the law. They're basically given free rein. And knowing that they won't be disciplined by the board, again, please note that this is not only gender identity and expression protected by the law, but the rights of mental health care patients in general is also protected. If such a large number of complaints are dismissed as the Human Rights Commission has accepted as evidence, then by extension, the argument that they have engaged in discrimination of others holds true. Again, this is the clear example of prima facie, I hope I pronounced that right, argument that in this case, though, the finding investigator claims that there was not a prima facie argument. I'm saying, this is a pretty good argument to that. And the argument was kind of self-evident in my rebuttal, which is quite lengthy and includes many exhibits of evidence that I've provided. Regarding the board's failure to act, in spite of the overwhelming and probative evidence, the board failed to enforce its own rules and regulations. As above, if therapists know that they will not be the subject of discipline, they are free to discriminate against their patients, knowing that they won't be disciplined. This is demonstrated by both allowing the therapist in question, this is my therapist, to number one, willfully give false and misleading statements concerning her patient, myself, the complainant, in regards to a medication that I was taking. This is domperidone. My therapist said it's been banned by the FDA for many, many years, and that I was taking it for breast growth, which is completely slanderous and completely false. I was taking it for gastrointestinal things. And again, in my response, I provided the evidence that no, the FDA does allow it. It is allowed under a special program. I am part of that program. The relevant code which the Maine Social Workers Board operates under, Part 1, Board Interpretation of Certain Grounds for Discipline, and the National Association of Social Workers Code of Ethics, which the board also operates under this was given as Exhibit A. They operate under that one as well. The relevant National Association of Social Work Ethics are 4.04, dishonesty, fraud, and deception. Number 2, regarding the willful cause of stress to me, the evidence was provided in the form of a reporting of the session, where I basically said to my therapist, please stop. I am going to quit. Just please stop harping on me. This is causing me stress. And in that recording, I get either it was a laugh, and it was a kind of who cares? I certainly don't. That's willfully causing me, stress and emotional damage. I don't know about you, but I don't know if anyone here is a smoker, but before I quit, and I have quit, if I go to my doctor, my doctor says, please quit. I've been telling you about it. And I say to my doctor, I get it. Just please, this is just too much for me. The doctor says, okay, no problem. I told you, and again, under the Maine Social Worker Board of certain grounds for discipline, again, as I've spoken of above, under misconduct, willfully causing a client physical or emotional harm is grounds for discipline. Number 3 is the board's minimization of the scope. I'm not sure if anyone here is familiar with the web portal entry, but it limits the amount that could be entered in as part of the complaint. I did enter in a lot more as part of that complaint. And that one in their own board meetings, when it came to my complaint, the response and that kind of thing, it was pretty much overlooked. Again, I'll continue with the March 10th meeting. The exhibits presented in my rebuttal, J1 through J8, they clearly show that the answer from the board is completely false. The answer from the board was, well, we understood that you had to meet that the complainant and me had to be made a co-host of the meeting, and it's completely false. As the exhibits show, it's simply a matter of saying allow recording. I'm not sure if any of the board members here are more familiar with the Zoom function, but when someone asks to record meetings, as I've said, it pops up, it says allow recording. Now the investigator saying that I was able to record it with my own device, that's kind of I find that kind of wrong, because I couldn't record it with the Zoom's built-in function, and I missed a pretty big chunk of the meeting as I kind of scrambled to find, some way of recording audio. Okay, I can take a picture. Okay, I can do this, but I wasn't allowed to record the meeting in its full as I should have been, and as allowed by law. And again, they never
Montane,
did.
that was 7 minutes. I'm gonna
Okay,
start a timer for your last 3, just so you know.
thank you.
Do you want to continue or are you all set?
I'm all set. Thank you.
Okay, commissioner questions for Ms. Lamontagne? Seeing none, you'll have 3 minutes when we come back to you. Attorney Morrell? Want to save any of your time?
Good morning, Commissioners. My name is Kelly Morrell. I'm Assistant Attorney General, and I represent the Board of Social Worker Licensure. The board is requesting that the commission adopt the investigator's recommended finding of no reasonable grounds in this case. Ms. Lamontagne filed 2 complaints in February and March of 2022, alleging complaints against her then therapist. One was that the therapist disclosed information in violation of HIPAA by releasing a diagnosis to their billing agent. She also alleged that the therapist violated HIPAA by writing a letter to the person who was going to do the surgery. So the purpose of the board is to protect the public, obviously, from harm. The board is made up of 7 members, 5 social workers, 2 members of the public. The board has a specific protocol that they follow for every complaint. It involves allowing the complainant to submit a written response, and then allowing the subject of the complaint to submit a written response, and then allowing the complainant to respond to that. The board has a complaint committee that kind of reviews everything that's been submitted, and then makes a presentation and a recommendation to the board at the meeting as to whether the board should take action on the complaint. And that's what happened in this case. There was nothing different about the complainant's complaints in this case. The board followed its established protocol. In this case, at the board's meeting in June of 2022, it voted to dismiss the complaints that were filed by the complainant. And the board looks at whether the evidence shows that there was either a violation of law or rule here. As the complainant pointed out, the board gave information during this investigation that in 21 and 22, 66 out of 93 complaints were dismissed at the board level. So it's not whether someone is unhappy with their provider, it's whether there was a violation of a law or rule. And that's what happened in this case. Now, after the dismissal of the
the complainant's two complaints, she filed another complaint in December of 2022 alleging that the provider did not obtain written consent for treatment from her. And the board, the complaint committee wasn't really sure what to do with this complaint. It wasn't brought up in the initial complaint, so the board complaint committee gave it to the board to consider at the March 23 meeting. And there was a discussion at that meeting about what to do with this additional complaint. And concerns were raised by the board, two board members, that they felt that this last complaint was mean-spirited. They were concerned that it was mean-spirited because it was not brought up in the first two complaints. And it was noted that the complainant had treated with this therapist previously from 2002 to 2011, and then restarted treatment in 2021 and 2022. And this was during COVID, this was during telehealth. So there was a concern that the complainant may not have had a legitimate complaint about whether there was consent for treatment or not, but maybe was trying to get this therapist in trouble. So the board determined not to take action on this last complaint and also dismissed it. They treated it like a request for reconsideration and dismissed the last complaint. So I would say in this case, there's no evidence of discriminatory animus here. The board treated these complaints the same as they would have treated other complaints that they've had. As far as the Zoom recording, I think the board staff was under the impression at the time that they had to turn over hosting responsibilities in order to record. That may have been wrong, but the issue is not whether it was wrong or right. It's what they believed at the time and whether it was discriminatory. There's no evidence in the record that the complainant was treated differently here, that other people were given, rights to record via Zoom. And she did have the opportunity to record using her own cell phone, and she did. And I actually listened to the recording that she provided to the commission of March meeting. So again, the board would ask that the commission adopt the recommended finding of the investigator in this case of no reasonable grounds, and I'm happy to answer any questions.
Commissioner Sanders and then Commissioner Davis.
Sure. Curious about footnote 1 in the report. It appears that that you've taken the position that the respondent, right, the Board of Social Work, is not a public accommodation as defined by the Maine Human Rights Act. There's an answer to that position in footnote 1, and I'm curious about, is that still the board's position?
I think we make that argument generally in these types of cases because I don't think it's completely clear. I think in the Maine Human Rights Act, it defines a public accommodation as a place or a building, a place of public accommodation. In this case, I think it's questionable as to whether it's a public accommodation. I think it might be more of a public service, maybe. But I don't think we're not disputing it here today. But we'll indeed.
So you're not relying on that?
No.
It seems to me you didn't quite finish the discussion about the allegation of a HIPAA violation and the letter to the surgeon. You're saying that it wasn't a violation, it was permissible, and that the letter to the surgeon was required.
I'm saying that's what the board said. I mean, I don't think it's my position to second guess the board's.
Did they say it in a written decision, or
they
just dismissed?
Yes, they just basically say there's not a violation of our rule. So I don't know the details of how the decision was.
And I smiled when you cited the complainant cites it too, the 63 dismissals out of 90. Why would they bring that up? I mean, is that evidence?
I think it is. I think it's evidence that I think the complainant's argument was they didn't take my complaint seriously. They dismissed it. It's evidence
and how is it that they dismissed most of the complaints? A response to whether they took her seriously.
It's because she was not singled out and treated differently from other complainants. I think that's the point, that This is not a
They
unique
don't pay
situation.
attention to any complaints. I mean,
Well, I mean, certainly that's not what I'm saying.
No, no,
What I'm saying, I wanted to stress the fact that when a complaint is filed, they look at whether there's a violation of law or rule. I'm sure they get a lot of complaints from people who are just not happy with
right.
the services they're getting.
I-
And that's
It
not,
doesn't bother me that in fact, that's true. They get a lot of bogus complaints and people that are just unhappy and they file a complaint. And so most of them get dismissed, but it doesn't seem to me to be relevant evidence for this complainant in this case to say, oh, we dismissed most of them anyway.
I think that what she's arguing is that, that's probative of the
Okay.
fact that the complainant here was not given short shrift, right? That-
Okay.
That her complaint was treated in a manner that all complaints are treated in, you know.
Right.
correct.
To your point, right, here too, the board followed its policy with respect to intake, assessment, referral onto the board for a decision about.
Okay, I'm being I apologize. You did say, I just want to confirm, you said that, and it's in the record, that this complainant treated this therapist from 2002 to 2011,
2007 to 2011, yes,
2007 to 2000.
correct.
Thank you.
One clarifying question about something you just noted, which is, you know, here, right, the board's job is to assess whether there's a violation of law or a violation of policy or ethical standard. So I think I heard you say that it's not clear to you what the board decided with respect to whether in fact there was a HIPAA violation. I'm just curious about, isn't that something that the board would solicit your legal assessment about or on in order to make that determination?
I actually don't represent the board as the regular attorney. There's another assistant attorney general. I handle discrimination claims for all the agencies, so.
And do you
Yeah.
know if that was the case, that the other attorney provided legal guidance with respect to the question about HIPAA violation?
Yeah, that AAG is actually a member of the complaint committee, so she would have been the one to review the submissions. Yes.
I just wanna summarize what I think it is you're saying, right?
Yes.
Which is basically that regardless of how the board decided the complaint, right? You know, the allegations, regardless whether, you know, these things are, you know, a violation of law or not. You know, how many dismissals, all this sort of thing. Your argument is simply that the board followed its usual practices or procedures of deciding these cases without any discriminatory animus towards the complaint.
Correct.
Am I right?
Correct.
Just to sort of sum it up in a nice neat little.
Once again, yes, correct.
Any other questions for Attorney Moore? Being done, you'll have about 5 minutes and 18 seconds.
Thank you.
Ms. Lamontagne, you have 3 minutes if there's anything else you'd like to add.
I'd just like to add that it's always been the board's position that there was no violation of law or rule. Again, I'm going to point to my argument that clearly brings up their own bylaws and their own rules as far as criteria for discipline and exactly how these rules were violated. So I think I'm trying to just make it clear that yes, this is my opinion. This is, you know, I've provided, this is the evidence to say that no, this is quite clearly wrong, that they did violate their own law, their own rules and their own law for it. As another quick clarification, when it comes to the surgeon delaying my surgery as a part of the response from my therapist, that was not part of the HIPAA. That was not part of my complaint that it was this against HIPAA. It was part of my complaint that my therapist herself was preventing me from having the surgery, and thus this is another way that my therapist was acting harmful or negligent towards me. And again, in the report, I just like to bring up, I haven't seen any evidence, any public evidence of their supposed claim that 66 and 93 was dismissed. I have not found any public reference for it. And again, thank you.
Yeah, Yes.
Are you saying that the letter to the surgeon was factually incorrect? I mean, I understand that it wasn't saying what you wanted because you wanted to move ahead with the timeline, but was it wrong in your opinion?
The therapist's basic opinion was that my surgery should be delayed because I just quit smoking, which I've yet to find a therapist or, I just think that is completely wrong. And it was placing a barrier to my care with this surgeon. Basically saying, oh, you should delay her surgery because she just quit smoking. Instead of saying she's a smoker, give her more time to quit smoking. It was, oh, she quit. You should give her time as a non-smoker, which is completely absurd. So that was, that's why I brought that part of the complaint up to saying she's putting a barrier to me getting the proper surgery for my condition, basically by inventing a non-issue.
Thank you.
Thank you.
The other commissioner questions for Ms. Lamontagne? Seeing none, thank you, Ms. Lamontagne. Attorney Morrell, you have, like I said, 5 minutes and 18 seconds. If there's anything else you'd like to add.
I don't have anything further unless the commission has questions.
Thank you very much. We've heard from the parties, and next we'll hear from Angela Morse, the investigator assigned to this.
Hi there. I'm Angela Morse. I was the investigator assigned to this case. I think that Commissioner Douglas's summary was a good encapsulation of this complaint matter. I'm certainly willing to answer any questions.
Any commissioner questions for Investigator Morse?
I just want to say good morning and happy New Year.
All right, seeing none, thank you, Angela. We've heard from, and thank you, Commissioner Douglas, for summarizing Angela's case so nicely. No, where am I? We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding.
Yeah, I'll move that there are no reasonable grounds to believe that the State Board of Social Worker Licensure discriminated against the complainant on the basis of sexual orientation or gender identity, and the complaint should be dismissed according to 5 MRS 4612 subsection 2.
Second. Moved and seconded. Any discussion?
I would just simply note that there is no evidence in this record whatsoever that any of these actions were motivated by any sort of discriminatory bias. I understand that sometimes we don't like what happens, but there's no evidence of what happened was motivated by discrimination. So there's no basis for finding.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing. Now, Sonord.
Yes, the last case for hearing is HB 240123, Isthmus Fenord versus SHP Management. It is a recommendation for a finding of no reasonable grounds on the account. Therefore, we will hear from the complaint.
Good morning, commissioners, executive director, council, attorney Hale. Today, I'm grateful to be able to present Mr. Fenord's case. Mr. Fenord has brought claims for retaliation and discrimination on the basis of race and national origin. Mr. Fenord has objected.
Your name?
Attorney Martin Tart.
Martin
Tart.
Thank you. All right.
And so there's a few bases in which we'd like to object to the investigator's report. And I'll go through them briefly, but essentially there has been a misapplication of the correct causation legal standard under the Maine Whistleblower Protection Act and other retaliation claims. There is omissions in the record regarding who the actual decision maker is and the failure to apply subordinate bias to the facts that are in the record. And the final basis is the dismissal of the complainant's contention that the reasons for termination have been shifted. So beginning with the correct legal standard, the Maine Whistleblower Protection Act and retaliation generally in Maine follows a substantial factor causation standard, not a but-for causation standard. This has been the law in the state of Maine for about 10 years now, since the Brady decision. My chief concern about this particular issue is that in the investigator's report, she states on page 5, in the final stage of the analysis, complainant was unable to show that but for his protected activity, he would not have been discharged. The problem with that is that is an incorrect statement of law under the Maine Whistleblower Protection Act. It is not but for, it is a substantial factor. And this is an issue that I think is very important from a legal perspective, because so much of employment law, so much of discrimination, so much of it goes back to this: what is the standard? What is the causation standard? Is it but for? Is it some sort of lesser standard? Is it a motivating factor standard? Maine, under the Whistleblower Protection Act, it is a substantial factor. And I think what really emphasizes the importance of this standard is that the reasonable ground standard under the Maine Human Rights Act is even chance, which I read that to mean 50-50 or a coin flip, essentially. So if there's an even chance that this was a factor in the decision maker's mind, that race, national origin, or Mr. Fenord's protected activity, if that was in their mind at the time that they were making the decision to terminate, then the Whistleblower Protection Act has been violated and there's been retaliation. It's not but for. The reason why but for is such a big deal is because when we think of but for, we think of the sole cause. We think that it has to be but for. And that's just not what the standard is. The law court has recognized that it is a substantial factor test. And this kind of leads into a similar related issue, which is this omission in the record regarding who the actual decision maker is. So this has been something that has vexed me and Mr. Fenord throughout these proceedings, is that we don't know who actually had the final say, who actually made the decision to terminate his employment. And this is just such a central issue to any discrimination, any employment claim ever, is who made the decision to terminate his employment. If you don't know who had the actual final say, then you can't say at all whether discrimination or retaliation motivated the decision to terminate his employment. Now, it's possible that, and the investigator concluded, and we dispute this, that they all came together and made this decision as some sort of panel, like a voting mechanism. But there was no testimony, there's no record evidence whatsoever that this was some kind of group decision. We have some, statements in response to the RFA that there were 4 individuals involved in the decision to terminate, but we don't know which one of them actually had the final say, or if it was a group decision. That's not in the record. If it was in a group decision, then we need to know what the group relied on, how they made the decision. Did they vote on it? Did they come together to decide it? We don't have any of that here, so we have no idea who had the final say. And if it was a group decision, we do not know how that decision was made, what was relied upon in making that decision. All we have are affidavits that vaguely state that, we came to this decision, we did this. There was a question during the issues and resolution that was, I'm not going to use his name, but it was Mr. F. I believe he's been referred to as the area manager. He had started working about the decision he was saying that the decision to find a new maintenance technician had been ongoing that time that he came on. So it's questionable whether he actually made the decision to terminate or what his involvement was in it. But either way, just the fact that if he was the decision maker, then we need to engage in a subordinate bias analysis and figure out what it was that he relied on in making his decision. So that's a pretty significant gap in the evidentiary record regarding who it is that made this decision. We submit that, there's no evidence in the record that it was a joint decision. All we know is that there's these affidavits that vaguely reference the decision-making process, but we don't have anything concrete from the record. And then the final area is just this shifting reason for termination. So this is like the quintessential pretext evidence. It's almost the first one cited in, I think, just about every judicial opinion is, was there a shifting reason for termination? In this case, when we requested the personnel file and the reason for termination, Mr. Fenord's reason for termination was it was no cause and they needed a different skill set. That was the reason that they gave when he was fired. That was the first reason. There was nothing in the personnel file about disciplinary records. There was the personnel file that we received when we requested it. There was nothing in there about discipline, performance, or anything of that nature. But the second that Mr. Fenord files his charge of discrimination, we get this bulked up, beefed up personnel file that has, that has some written disciplines that he's never seen. And it also has Exhibit F. And Exhibit F I'd like to return to in a moment. But so now they've shifted from different skill set, no cause, to something that looks a lot like cause, performance issues. Now, all of a sudden, Mr. Fenord's employment is at issue. His performance is a problem. And like I said, it's a shifting reason. The investigator claimed that, it was just a matter of wording and semantics, essentially. But the problem with that is when you say no cause and a different skill set, you're implying that there is some new thing that he's not doing, that he should be doing, that wasn't expected before. We're going in a different direction. We need a different skill set. But there's no evidence that that means that there's a performance issue. A performance issue is a for cause. It is a problem that needs to be rectified. And that is not what they stated at the outset. It only turned into a performance issue when Mr. Fenord filed his charge of discrimination. And the final thing is that this Exhibit F that the respondent submitted in support of their position statement is, I think, to be documentary evidence of his protected activity. It states in there that the direct supervisor who referred to Mr. Fenord as Smitty, and at one point during the proceedings, exacerbated during the issues and resolution conference, he said, he's lazy, which is a racial stereotype. When you're saying that a Black man who is an immigrant is lazy, it's a racial stereotype, unfortunately. And that was said during the issues and resolution conference. He also mentioned that he couldn't pronounce Mr. Fenord's name, so we called him Smitty. And hearing those things, it was pretty difficult to listen to that. And we also have evidence from his coworker that he told Mr. Fenord to go speak to his people. So if the standard is an even chance, for me, if it's an even chance that we prevail at trial, that to me would suggest that discrimination has occurred and there should be a reasonable cause finding. But Exhibit F in particular, it mentions that Mr. Fenord talked about an emergency, and that's what we alleged his protected activity to be, that he had to address emergencies before clocking in. And this document, Exhibit F, references that. And Mr. Fenord, by the way, has never seen this document, and it was not in his personnel file when we requested it. But this to me is documentary evidence. Again, an even chance. Was this a factor? Was this a factor that made a difference in their decision to terminate Mr. Fenord's employment? Well, they used it in support of their reason for termination. So if they're using this in support of their reason for termination, and this reflects his protected activity, then that is certainly even chance that he was retaliated against. And with that, I will reserve my time.
9 seconds. Any other questions for Attorney Chart?
Oh, sorry.
Yes, good morning and happy new year. So I read your submission. First of all, I very much enjoyed your submission. I like people that sort of lay it all out, and you laid out a bunch of very useful quotes and things. So thank you for that. I found that to be very helpful myself. In terms of the evidence of subordinate bias, right? You cite a few things. The fact that Mr. Fenord was called lazy, right? The fact that the supervisor referred to him as Smitty and Fenord, they sound exactly alike. And the fact that he said, go talk to your people, right? It's the same guy. Is there anything else?
Generally, well, no, but that he was aware that Mr. Fenord was, was advocating for the tenants that couldn't speak English. And I think that a really I think it's significant because generally, like if this were a summary judgment in trial, okay, and there was a factual dispute, and we had Lazy, and we had couldn't pronounce his name, and if we had just those two things, I feel that we would be able to survive summary judgment. And there's the other fact too, that he was replaced by a white guy. And so,
And this supervisor that we're talking about, this is the person that was brought in right near the end,
yes.
right?
Oh,
So the
well,
respondent takes over in 2018, and then supervisor comes on, right? And all of a sudden starts finding all these issues with Mr. Fenord's work. Do I have that right?
mhm.
Okay. In terms of the reasons for discharge, lack of skill set versus different skill set. But what gives me pause about that is the white coworker, right? Am I correct that there's an affidavit in the record from this coworker who is doing basically the same job as Mr. Fenord, saying that they had identical skill sets or something to that effect?
Mhm. Yes.
And do I understand correctly that the white coworker was retained? Like he stayed on after Mr. Fenord was fired? Is that correct?
Yes, that's my understanding, yes.
Okay, so they have identical skill sets. I mean, I'm just sort of trying to summarize your case, because that's my thing this morning. So you're claiming that there are two guys there, they're doing maintenance, right? They have identical skill sets, at least according to this affidavit. The person of color is let go. The white guy with the same skill set gets to stay on. Is that your?
Yes, sir.
Okay.
That's the prima facie
And then the
case.
subordinate bias would be what we discussed before.
Yes, and I would just like to note that we really don't have a lot for subordinate bias because those areas of inquiry were not explored, because in order to do subordinate bias, you need to know who the actual decision maker is. If you don't know who the actual decision maker is, how can you say that any of this report is valid? You don't know who you're probing for discrimination or what they were thinking. That's why it's so important. You know, I would say that honestly, it's probably the first question that should ever be asked in any employment case ever is who made the decision to terminate? Because then we can understand, was this one final say? Because a lot of times what happens is there's some higher personnel, right? And then the decision is a supervisor, let's say he's got some animus, and he reports to this higher person who doesn't really know what's going on and says, yeah, this person violated company policy, then they get fired, right? So that is your classic cat's paw subordinate bias factual, but you don't even get to that unless you know who the actual decision maker was. So if you just have that piece of information, it makes a whole lot of difference in a case.
Do you want to address the business about clocking in and out during emergencies? Is there anything that needs to be said about that from your perspective?
Only from the standpoint that it was protected under the Maine Whistleblower Protection Act because he was addressing what he believed to be an unsafe practice, which would be to have to not go directly to the emergency and instead go do some clocking in, clocking out and office policy before, like, let's say there's a fire or something, right? So that's what Mr. Fenord was trying to express when he said, look, I got to address tenant emergencies before I go and clock in.
Is there any evidence in the record as to what the other employee similar to Mr. Fenord was doing at in similar circumstances? Was he clocking in and out? Was he going to the emergency first?
I don't believe
if it's in the record.
I don't believe we have that in the record.
Thank you.
What are the dates?
The dates?
The dates of his employment.
He worked there, you worked there for you worked at that building for
10 years together.
For 10 years. SHP came on in 2018. So we worked for SHP for a number of years before these new managers came on. And that's when things changed.
The new managers in 2018.
The new managers were, I believe, Mr. T was 20 something, wasn't he? 2021.
Yes, the manager.
Yeah, Mr. T. I can't say his name, but you're a supervisor.
Oh, Park. You don't get 2 years. You only year and a half.
Yeah, so his direct supervisor was about a year. And then the area manager, Mr. F, was about like a month, maybe.
But that's a significant factor in your timeline that area manager comes on and he has the animus to to see him fired, right?
Well, that's possible if he was the one who had the final say on the decision to terminate, but we don't know.
For suspicion, is it not?
It's one of them. According to the report, it was a group of them. Which we dispute, but we just don't know. We don't know.
Any other questions for Attorney? Attorney Hale?
Yeah, good morning. I want to respond to a few specific comments by Attorney Tart first. The standard is substantial motivating factor. I think that is correct. But what we have here is something that even with the facts in the record, they do not meet that standard. The comments that Attorney Tart has noted, the comment about lazy, the comment about his people, and his allegation that a witness at the IRC said he called him Smitty because he couldn't pronounce his names. There's no connection between those and any indication of discriminatory, retaliatory animus. There's also this whole argument about decision makers. And if we look at the affidavits, Attorney Tart has said that they're vague and there's no clear indication of who the decision maker is. If you look at the affidavits, they all do say CF, KF, KJ determined that they were better served with a maintenance tech that had the skill sets of a maintenance tech. It is more about semantics. He didn't possess the skill set that they needed for that position, and it was performance at the same time. He was unable to perform certain job duties that were expected of him. And so at the end of the day, and no, I do disagree with Attorney Tart's characterization that the other white employee who was not terminated had a similar skill set. That is not true. That employee was more experienced. That employee did have a significantly greater skill set, was able to do a lot of work that Mr. Fenord was not able to do. And so there isn't an equivalence there. It isn't a situation where in some race discrimination cases, you have two employees, the exact same qualifications, the exact or similar performance. One is in a protected class, the other one isn't. And that's not the case here. There is not a similarity. Also, in terms of the decision makers, none of this factors into substantial motivating factor. The fact that there are several people who were involved in the decision to terminate Mr. Fenord's employment doesn't suggest that there was any discussion of race, any discussion of protected activity. And I will also note that the investigator was correct in finding, I don't see protected activity in this case anywhere. I mean, that's what we have to establish here, is he's claiming he was terminated because in retaliation for making complaints related to race or violation of some statute. And there just isn't that. We don't have that in the record. And he's not providing any kind of direct evidence that race or their protected activity was at all a factor in those discussions. In fact, in the IRC, when the investigator was questioning the witnesses attested that race, protected activity, none of that was part of the discussion about the termination of employment. It was about skill set, it was about performance, and there were not shifting grounds for the reasons for termination. It was skill set. He couldn't do functions effectively that were expected of people in that position. You can call it performance also, but he was incapable of doing things that they needed him to do effectively. And that is skill set. Attorney Tart also mentioned, this case might get over summary judgment because of the discussion about being lazy. And I think it goes without saying, however, whether a case can prevail on summary judgment certainly doesn't mean that it meets the substantial motivating factor standard. In that case, it's just about, is there an issue of fact or not? could someone interpret lazy as a racially motivated comment or not? That is not what we're dealing with here at the commission. The commission does need to find if there were reasonable grounds to find that discrimination occurred. And there is nothing in the record, even if they don't identify a single decision maker. It doesn't have to be a single decision maker. It can be a group of people in a meeting coming to a consensus that termination of this individual's employment is appropriate because he's not doing the work effectively. He doesn't have the skill set. In many cases, there was an instance, and I think it's in the record, where the individual who did provide that affidavit was going around doing work while Mr. Fenord was sitting in the truck looking at his phone. So after these instances, the decision was made. So I think for all those reasons and the fact that there really is no evidence in the record that would suggest that there was any causal connection between protected activity or protected class and the decision to terminate his employment, I think the investigator's report was spot on, and I think the commission should adopt her findings.
Questions for Attorney Hale? Commissioner Douglas.
Yes, Attorney Hale, good morning. Happy New Year. I see
Morning.
your partner in crime, Susie Dowling, on there as well. Happy New Year to you as well. I think that the thing that sticks out in the report and the record that we have in front of us the most is this business about the other coworker, the white coworker who apparently submitted an affidavit that he had a identical skill set. Or something to that effect. Mm-hmm. And I'm just wondering, you refuted that, you've stated that they had different skill sets, he was capable of doing a lot more, and I'm just wondering if you could be more specific with reference to facts that are in the record in this matter.
In terms of what's in the record, I believe, well, I mean, whatever's in the record likely was discussed at the IRC. Some of the things that, for example, the individual who wrote the affidavit was skilled at things involving HVAC. He could do a lot more. He could perform significantly more repairs effectively than Mr. Fenord. He had more years of experience. He was more reliable, and I think that's critical to point out. I will also note that even if you were to find that this individual, I think it only goes to a prima facie case. I think there's two pieces here in a retaliation case. There's a prima facie case and then there's pretext. And so to show pretext, we'd have to show inconsistent reasons for termination. And they'd have to show that the real reason for the termination was some connection between the protected activity or characteristic and the decision to terminate. And I think that's where they really fall short here, is there is no evidence of inconsistent or shifting reasons. And then when we provided a legitimate business reason that is backed up with documentation, that is backed up with testimony from people who discuss the fact that there was no at all discussion about protected activity in the decision to terminate, there's just no evidence of pretext here. And I think there are things in the record that can distinguish this individual from Mr. Fenord, and the fact that this individual could perform a lot of tasks that Mr. Fenord could not. I mean, he was not without performance issues, but I think that's just one very small piece of the puzzle that I don't think gets them over the hump of a non-reasonable grounds finding.
And just in terms of what you've identified, respective differences between these two men, HVAC, years of experience and more reliable. On the more reliable piece, is there evidence in the record that this was addressed with Mr. Fenord? This came up before he was terminated?
The reliability piece, I believe it was. Let me pull up. I mean, you have, I think, you know, you have the exhibit F, and I will note that, you know, whether these things were included in the personnel file or not, I understand that, and there's other remedies for the complainant that he can pursue with that. But that doesn't mean that these things are not authentic and they don't speak to the issue of was there pretext, were there documented discussions regarding his performance? But you have exhibit F that talks about, you know, company trucks should be turned off and not running while using projects, while tasks are being performed, complying with work order policy. We have something from 2021, you know, failure to, let's see here, failure to lock the basement door. I mean, basically, these are things where they can't trust him to do things in accordance with policy that are expected of him. So reliability, it's not just about do I show up to work on time? It is, can I trust you to comply with company policy? Can I trust you to turn off a truck and not keep it running while other projects are being performed? I mean, that's a risk to company property failing to do that. So he was counseled for these things. Whether or not they were in the personnel file that was originally offered to him, I think that's an entirely different issue that really isn't relevant to the investigator's report. So I think that's our position. I think it is documented and he was informed of this beforehand.
Thank you.
Any other questions for Attorney Hale? Seeing none, you'll have about 4 minutes when we come back to you. Attorney Tart, you have 9 seconds, which is probably about enough time to come up and ask if the commissioners have any further questions for you.
I can squeeze in something in
Okay.
9 seconds. One, there was no HVAC in that building. It was a boiler. Okay, they never did HVAC there. And 2, coin flip, even chance, even chance. That's what the standard is.
Any further commissioner questions for Attorney Tart?
Impressed.
That was it. And any further commissioner questions for Attorney Tart?
I do, actually.
Oh, sorry.
Come on. I'm just trying to get to the bottom of, you know, difference between these two employees. Because I think at trial, that's your case. With standards, even chances, right? I think that's your case. I think your case is you're gonna get in there, you're gonna say, you know, respondent takes over, they hire a new supervisor, the supervisor's got, you know, an issue, right? He's got some animus there. He's gonna, you know, you're gonna cite this evidence that you cited for me, which admittedly is kind of sparse, right? Lazy, Smitty, his people. But then you're gonna go to this business about the 2 employees, right? The person of color and the white guy. And what you're gonna say, I think, what I would say is that they're basically the same guy, right? They have the same skill sets. They both have deficiencies and so on and so forth, but the person of color gets let go and the white guy stays, right? So Attorney Hale is drawing a distinction between these two, you know, years of experience, reliability. Let's go to reliability. Is there, from your perspective, is there evidence in this record demonstrating that your client was less reliable, however we're going to characterize that, than the white gentleman?
There's conflicting evidence because the white gentleman who stayed on has testified in his affidavit that they had identical skill sets and he worked closely with him all the time. In terms of reliability, I disagree with Attorney Hale. I don't think that there's any evidence that he was unreliable. I think that the written performance issues, well, actually I should say discipline, because they weren't checked off as performance issues. They were code of conduct issues before 2021. So according to SHP in their document, those aren't even performance issues. Okay, so I'll deal with the only one that was a performance issue, which was Exhibit F. There's nothing in there that to me says anything about reliability. What that says in Exhibit F is it's talking about complying with company policy regarding work orders and clocking in, which again, you got my discrimination case correct. There is also the retaliation case, okay? So there needs to be findings on both of those issues, but yes, the discrimination case, a lot of it does come down to the fact that they kept on the white guy and then they hired another white guy instead of him. And those comments, and I disagree that they're sparse. I think they're pretty loaded comments, and I would have an expert witness testify and explain why they're loaded comments. But let's for the sake of argument, let's say that they're sparse. Maybe they are sparse, but it's enough to get over the even chance coin flip standard, because when you have the white comparator and then you have the person who came and filled in the position that's also white, and then you've got these comments in there too, you've got more than an even chance, respectfully.
Just refresh my memory here. Before this supervisor, this problematic supervisor came on, any issues with your client's performance that were documented that are in the?
I would say no. I would say that the other written disciplines are code of conduct. They're not marked or checked off as performance on their own document. And that document, those documents that are in the file, they're not performance documents. They're code of conduct. And so maybe they can cite to code of conduct, but then they're just adding new reasons for termination. Okay, that's a new reason. Saying, well, now it's performance and code of conduct. So now we're just adding new things in to support, like, we were going to fire this guy anyway. Look, performance issues, code of conduct. And you know what? The initial reason was no cause. He's a great guy. No cause. Different direction. Different skill set. No cause. No cause. That's a pretty powerful term in my mind. No cause. There's no reason. We're not firing you for any reason, for anything that you did. It's no cause. We're firing you instead because we just need something different. We need something different that we're not getting from you. Okay. And now when he files the charge, it's all about how terrible of an employee he was, just listing things off like, oh yeah. And then that one time he was in the truck watching videos, it's just at this point, they're just listing things. So.
All right, thank you.
Any other questions for Attorney Tardy? None? Thank you. Attorney Hale, you have 4 minutes and 10 seconds.
Okay, thank you. Just a few points that I'd like to make from things that were said at the IRC. There was significant differences. There were many differences between Mr. Fenord and the employee Dave, who submitted the affidavit.
Hale, please don't use third parties' names.
Oh, I'm sorry. The individual D. Who they provided an affidavit, and there was testimony at the IRC where the decision makers said D was far more reliable. He was motivated. He was a self-starter. He was a good planner, and he was more qualified than Mr. Fenord. And he was also very close to retiring. And they gave explicit examples of times when D performed in a manner that was superior to Mr. Fenord. In one situation, he met with the property manager who was supposed to be picking up trash around the campus. They got there. D was around picking up trash around the campus. D was doing his job, working hard, and Mr. Fenord was sitting in the truck watching news on his phone. Another example, of different skill set is there was a leak in one of the units. Mr. Fenord was asked to go and correct the leak in the unit. He was given specific instructions of how to repair the leak in the unit. He had to open up the wall, and when the property manager or maintenance supervisor came back to inspect it, he described it as it looked like he cut it open with a butter knife. And the tenant's property was covered in dust and junk was everywhere. And this was something that was expected of him, something that he was expected to know how to do in an effective and efficient way. And another specific example was the new employee who was brought in to replace Mr. Fenord had done the exact same thing virtually perfectly. And he had done it in a way that Mr. Fenord, according to these witnesses, would absolutely was not going to be capable of doing it. So the person who came on, that's just one example. And not only did he do it perfectly, he did it without instruction. So in that instance I just gave you, the maintenance supervisor had to go there and give Mr. Fenord step-by-step instructions. And even when he did that, it looked like he had done it with a butter knife. And the new employee was able to do it without instructions and did it virtually perfectly. And that was just one example of many. And there was also testimony at the IRC of D's significantly greater reliability, as I had just described. So those are all things that did come out at the IRC. The declaration that was provided by Mr. Fenord was not with his charge, it was in his rebuttal, and so we were able to respond to those things, and the investigator had an opportunity to ask questions about it, which our witnesses answered. And if we looked at if we looked at the transcript or recording of the IRC, it would support absolutely 100% a no reasonable grounds finding. Everything in that IRC supported that Mr. Fenord did not have the skill set. And any employment attorney knows when you're talking about cause, I mean, at least there is no cause or without cause under the Maine Human Rights Act. You see it in employment agreements all the time. And frankly, it is quite difficult to find cause. Usually performance issues or lack of skills will not qualify as cause. It has to be significant misconduct. It's the same thing before the Unemployment Commission. Somebody can have unsatisfactory performance or lack of a skill set, and they may still be found to be entitled to unemployment compensation. So this discussion about cause or no cause.
That's
Yes.
your time.
Okay, thank you.
Commissioner, questions for Attorney Hale? Commissioner Douglas.
Yes, I'm just looking at the complainant's submission here. And I'm looking at page 8. And he alleges that this Exhibit F that everybody's talking about, which we don't have in front of us, by the way. He said that the respondent never gave Mr. Fenord Exhibit F, nor did he sign that write-up. Instead, the supervisor signed and filled out Exhibit F as Paul for Smitty. Is that true?
I have to see this, hold on.
Yeah, I'm looking at page 8 of his submission there. Bottom paragraph.
Paul for Smitty. No, that doesn't say that. No. Signature witness, I agree.
You see where I'm reading from there, bottom of page 8?
Yes, no, I do. And I don't think that's not true that he didn't see that. I mean, he wrote a disagreement with it at the bottom of it. Because I am trying hard to get the residents to call the office to request work orders. Sometimes they can't reach the office or the work is an emergency, and I make sure Paul knows if the resident has requested repair. IS, and then it's there's an initial IS, and the Paul for Smitty, I mean, I think it's something like normally, I mean, if somebody signs on behalf, well, first of all, I'll say his signature is right here. I don't know if you have Exhibit F in front of you.
They don't.
We do not have Exhibit F.
Okay.
That's
Well,
why
first of all, I will say there are two, okay, so just to clarify, there are two places. There are 3 lines for signature. At the bottom of the, we'll call it employee coaching form, there is signature of employee, and the signature, under a signature of employee, it says, I agree, checks off agree, and then he signs it. Mr. Fenord signed under signature of employee. Under that is signature of witness / third party, Paul Tetzlaff, or sorry, PS or PT. And then under that is employee response, where the employee had the opportunity to provide his comments. And it's under that where it says Paul for Smitty. And PT signs under that. So Mr. Fenord actually signed the warning. But then under where the comments where he says, I'm trying hard to get the residents to call the office to request workarounds. Under there is the signature block where it says P for Smitty. Does that make sense? It's probably hard to visualize.
I don't know, I think I've got it. So what you're saying is that he signed this exhibit F.
Yes.
And there are comments that were submitted, and under the comments, it says Paul for Smitty.
Correct. And what I understand is that the comments were provided either verbally or over the phone. And then I believe PT transcribed them. But Mr. Fenord's signature is on this document.
Okay, thank you.
Any other questions for Attorney? Seeing none, we've heard from the parties, and next we'll hear from Jane O'Reilly, the investigator assigned.
Checking to see if we've reached afternoon yet. Nope, still morning.
Good morning again, commissioners. I was the investigator for this case, and I will just address a few things in the record that I was hearing that I believe have either been misstated or at least mischaracterized. One is the statement by Tech that he had the same skill set as the complainant. The affidavit says that the affidavit is Tech's assessment that Mr. Fenord, the complainant, had the required skill set. Doesn't say anything about his own skills in comparison to the complainant's. It says, complainant, Mr. Fenord did quality work. He was a skillful maintenance technician. The next paragraph 9, there were no aspects of the job that Mr. Fenord was unqualified to perform. And the next paragraph, Mr. Fenord performed every task that was asked of him. So I looked at it as further evidence that complainant was providing that he had the skill set required, trying to dispute respondent's characterization of his performance, not evidence that he had the same skill set as the white technician. So I just wanted to clarify that because it seems like that wording was important of the skill set itself. Also, it had the same thing about exhibit 7. There is comments by the complainant that were consistent with comments he gave me in the issues and resolutions conference about these requests being made to him from tenants. He was consistent that yes, sometimes people come up to me, they ask me to do things in their apartment and I do it. I believe there's a footnote in my report, which I can't look to right now, that says there was a dispute about whether he was getting paid for those jobs. He said, no, I was just trying to help people out. But either way, respondent had an issue with that because of the way they wanted to process work orders, based on emergency and based in timely fashion. They didn't want tenants being able to get maintenance done in their apartments just sort of by grabbing a maintenance technician. So I did not make a finding as to whether or not he was getting paid. I'll take his word for it that that was just the way he was doing those jobs. And then also, sorry, I'm going a little out of order because I want to make sure I get all of these, but along with the issue of the white maintenance technician who was kept on, my notes are consistent with what respondent's attorney has provided. And when I asked the supervisor, why did complainant, why was he selected for termination? Why didn't you, what was the issue? What were the skills of this other employee? He provided that Tech had was also not great. The sort of overarching thing was that basically prior to this property management company taking over this building, the jobs that complainant and Tech were performing were not the same jobs that this new company wanted them to do. Mr. Fenord, complainant, provided in the IRC that some of the work he was being asked to do now, the reason it wasn't being performed correctly was because he'd never been asked to do that work before. Contractors had done it. So the prior employers had maybe asked for different skills in those jobs. So when this new person came on, and the new maintenance supervisor started in November of 2022, they were asking them to do more and they weren't performing those tasks up to the level of skill necessary. Tech had slightly more skills, but even so, the reason they didn't consider termination was in part because he said he was close to retiring. So, I didn't ask more about, I do know from the affidavit that he did end up retiring. But that was the information given to me as to why those two things were compared. I also want to point out in these employment cases, when you're talking about discrimination, you don't have to be the worst at your job. You don't have to perform your job to a level that's so atrocious, it's obvious that you would be fired. You just have to show that you're either being compared unfairly to a member outside of your protected class, or that those issues were present, but they weren't an issue until something else, someone became aware of your race, or someone became aware of your protected class, and that's pretext for the decision to terminate. Neither of which I found in this investigation. Go back to my notes, but I think that's all I wanted to specifically point out about the record. And then I will address this issue of the legal standard, but let me just make sure I did that. I believe there was a question about whether or not the performance issues existed before the new area manager and the new maintenance supervisor came on board. Yes, they did. Some of the stuff they talked about was around it. There wasn't a direct supervisor for complainant other than the manager who was managing the whole property. So I think maybe it wasn't as, there were some conversations that were happening, issues, but it was when the maintenance supervisor was hired that those became more readily apparent and more addressed more formally. The lazy comment. So I am aware and understand that lazy is a racial stereotype. However, that was taken out of context. The supervisor said he was lazy and then immediately followed it up with a story describing that instance. It's the same instance that respondent's attorney has pointed out, where two employees, the tech and complainant, were both supposed to be maintaining the grounds. And tech was out maintaining the grounds, and complainant was in the truck, not performing those jobs. And I can address the shifting reasons. I think there's a footnote in my report about it. I can talk about it more if you have questions about that. But I think that's it for facts. And then I'll just, when it comes to the legal standard of substantial factor versus but for, in my view, as they've been stated today, they are very similar. But for is not sole reason. There can be other reasons as to why the person is terminated. But for is just without that factor, the termination would not have occurred, meaning it's a substantial factor in why that decision was being made. So for purposes of this case, substantial factor but for, my conclusion would be the same with regard to the evidence. If you do see those as sort of wildly different standards, I really don't see any evidence that race was a factor or retaliation was a factor at all. With regard to the evidence in this case, but to the extent it's there, it's certainly not substantial enough to be the reason that he was terminated. I can answer any questions. Okay.
I know.
I'm curious about, complainant alleges that initially the rationale for termination that was respondent gave to complainant included a characterization that the termination was not right. Respondent tried to very finely slice and dice, right? That expression, right, is tethered to talking about the unemployment context. We're talking about something different than. I'm trying to square that fact with what you articulate in footnote 7. So how do we understand if it's true, right, that the respondent communicated to complainant termination of employment was not tethered to cause, why subsequent explanations about performance issues, why are those not wavering or inconsistent or additional reasons for termination that could supply evidence of pretext?
Yeah. So this idea of performance concern, right? As opposed to skill set. The skill set of the job changed. So to the extent that they're talking about complaint was not a horrible maintenance technician. He had skills, he took care of the grounds, he performed his job as far as I can tell, and as far as, respondent didn't contend that prior to him owning this, they didn't inherit a bad employee, right? They had an employee who performed a specific job. They started to change that job, ask more of him, and he was not up for the task as characterized by respondent, right? Again, in these cases, I'm looking to see whether or not, whether or not he was so bad, obvious they should have gotten somebody else, not up for me to say, but the types of work they were asking him to do he was not performing to the level that they would expect, they were hoping or expecting that employee to perform as examples, the example of the wall. That is exactly how it was. My notes are consistent with what respondent articulated, that there was a repair that needed to be done, and the supervisor told him how to do the repair. He went in and did the repair in a way that was going to, could have caused damage to the property of the tenants, and otherwise was just not very skilled. So when they say performance issues, and when I say performance issues, performance reasons, it isn't misconduct. It isn't, he never showed up to work. It isn't, it isn't a bad employee in the sense that you might think of someone being a bad employee, who cannot perform skills, but someone who couldn't perform the skills they were asking for. So when they say, and I can get you the exact wording, so we all have the exact, I think it was stated a couple different ways, what the language is in the, I think it actually.
Attorney Tart, do you know that?
Do you have the letter?
Do you have the letter, Andy?
Oh, here we go. Okay, I have it. So it says, you are not being terminated for cause, rather the needs of SHP management have changed and we need a different skill set. That sentence to me is very consistent with what respondent then told me later, which was, we had this employee who was performing a specific job. We started to change the job. We needed different skills, because the skills we needed, he couldn't perform. Does that make sense? That's based on what was told to me in the IRC, the information I have, based on, and I asked complainant in the IRC, I said, do you disagree? Do you disagree that you couldn't perform the skills? What are your thoughts on a different skill set? And he responded that one of the things that he was asked to redo were apartment turnovers. So tenant leads, go in, clean the apartment, prepare for a new tenant. He was asked to redo that by both the maintenance supervisor and the area manager. And he said, I never had to do this before. We had a contractor who did apartment turnovers. So that to me was, again, further evidence supporting respondent's position that he, was doing these things and they were either new to him or he wasn't performing them. So
I guess my concern is that, and then, right, all of the information that's produced in the context of fact-finding process sounds an awful lot like performance issues, right? And so I guess maybe it's more of a rhetorical question, but wouldn't it have been nice? Respondent in that letter termination of employment that made out, right, with great specificity, all of the legitimate non-discriminatory reasons for termination. It would have been really helpful had the respondent done that instead of a sort of a 10,000 foot seemingly.
We could say that about almost every employment case we get.
So that's the point that I'll make. And I'm concerned about, to I think Attorney Tart's point is persuasive, right? That the letter.
Is it a question for the investigator?
I'm curious about, is Attorney Tart's position persuasive to you that, could we reasonably conclude that there are wavering or different or additive reasons that supported the termination, and could that be against?
Based on the entirety of the record, no. If you read that statement and says, for cause different skill set, that's the question I asked, right? That's the start of my investigation based on the information I had about what they were saying about his employment. I don't think they wrote that letter in preparation for a defense of a discrimination suit. So my, collective evidence that no, we're gonna shift anything.
The second employee that's hired, that's white, not the one they keep, the new one. Do we know what his skill set is? Is that in the record and is it comparable?
So the characterization that Attorney Hale gave of the same skill, basically this employee was a little bit more self-directed and independent in terms of the tasks he could perform. I don't believe he stayed with them for very long, and then they hired somebody else after that.
So that's an evaluation of his performance. I'm asking what he presented at.
Oh, like during his interview,
Yeah,
what was
what's
his skill
what's his
set?
resume?
I don't know that I have his resume
Yeah.
as part of the
Or what he
part of the
claimed he could
record,
do
so
or whatever.
yeah, I don't have like interview.
Okay.
I just asked him, I asked at the IRC, what could he do when he performed the job? I don't have the initial presentation hiring. I don't think, I can check the IRC notes.
Well, were you convinced that it was different new skills?
Yeah. Yeah, when they talked about the new skills of the
Superior
employee,
to complainant?
yes, they used a specific example of something complainant couldn't do with regard to the wall repair. And that this new employee could do. That was the example they used.
Oh, the new employee did that repair?
To do a similar repair without assistance, and I think even more than that, but I'm gonna take back that last part of that because I'm not convinced. But I can find.
Okay. Any other questions for Investigator O'Reilly?
Thank you.
Thank you. All right, so we've heard from the parties, heard from the investigator. At this time, we're looking for a motion. There's one proposed finding. Two proposed findings.
I move that there are no reasonable grounds to believe that SHP Management Corporation discriminated against Mr. Fenord on the basis of race, color, national origin and or ancestry. And two, there are no reasonable grounds to believe that SHP Management Corporation retaliated against Mr. Fenord for engaging in MHRA and or WPA protected activity, and the complaint should be dismissed in accordance with 5 MRS section 4612(7)(2).
Second?
Second, 1.5, but I guess it's.
I'll take it. Okay. Been moved and seconded. Discussion.
Yeah, I mean, I think that, the discussion that we've engaged with, with counsel in this case. I mean, I understand where both sides are coming from. The standard is an even chance at trial, and I can sort of see, as I've outlined, what complainant's case looks like at trial. I think it's a much closer question than perhaps some folks appreciate. So, the distinguishing in the affidavit between the same skill set and the required skill set, I mean, that still, to my mind, gets us to the same place. He had the skills to do the job. That's the testimony the complainant is going to present at trial. He had the skills to do the job. He was let go. And when you factor in all this other evidence, the fact that the low English proficiency folks were allegedly treated differently, and again, I think that the evidence on the subordinate bias is I still think it's a little sparse. But I understand what the case is, and it seems like a pretty close question to me. I'm just, so I'm wrestling with this one. I have to be honest.
I second that. I mean, I'm finding it a very, very close case and wrestling with it. And if I'm wrestling with it that much, that means that there's a reasonable chance he could prevail at trial. That it's in, it's not clear either way to a preponderance standard.
Just so that we're clear, our standard is lower than quadrants.
Yes or no?
Okay, I just, sorry, I heard preponderance and went, ah.
I don't think you react, no, I understand, I mean, that's the point, that if I'm wrestling with it that closely, that it's at least an even chance.
Further discussion? The motion is to find no reasonable grounds in both counts. If you're in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien? Yes. Commissioner Douglas?
No.
Commissioner Sanders?
No.
Motion you need to make then. Need a new, can I have a new motion, please?
I feel like I did this last.
You did. I'm passionate about it.
I'm sorry, I thought I was following what I was supposed to be doing.
I would like a new motion. That motion is failed.
Oh, maybe I wasn't confused this time. All right, so let's try that again then. I move that there are reasonable grounds to believe that SHP Management Corporation discriminated against Mr. Fenord on the basis of race, color, national origin, and or ancestry. Number two, there are reasonable grounds to believe that SHP Management Corporation retaliated against Mr. Fenord for engaging in MHRA and or WPA protected activity, and the complaint, I think it's the last part, should be forwarded for conciliation. That's fine. Pursuant to the right statutory reference.
Just a 3 instead of a 2.
Sub 3. Pursuant to 5 MRS section 4612 sub 3.
Second.
Right, so moved and seconded. Any other discussion? None. Motion is to find reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay, findings are reasonable grounds.
I know.
We appreciate everyone's participation. The commission will send a letter to the parties and council confirming the results of the hearing. Should we have a vote to go into executive session and then take a break while we get
Yes,
the
as long
text set up?
as we take a break, I will move that pursuant to one MRSA 4056E, I will go into executive session. Regarding pending contemplated litigation and the legal rights and duties.
Second. I assume no discussion. If you vote yes, you're in agreement. Commissioner David?
Yes.
Commissioner O'Brien? Commissioner Douglas?
What's it?
We're going into executive session.
Yes.
Commissioner Sanders?
Yes.
Okay.
Nice to go with you.
Thank you. So we need a motion not to litigate E 23-0182 Scott versus Green Pages Technology. So moved.
Second.
If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay, fantastic. Thank you. We'll see you all on February 10th.